my understanding is we've got quite a few issues to address. Among them are the issues of the child victim hearsay, and apparently for the
Yes, there's a.
TV people, I just did something to your microphone, unfortunately. Can you come do whatever you need to do? I'm sorry. I had the audacity of touching the microphone to kind of move it. I didn't mean to. Sorry about that. We've got exhibits. I know that there's some jury instructions that are wanting to be discussed. So are there other issues that we also have to address?
Don't believe so.
And did we figure out the shot clock from today?
I think we did. Did we get the? Is that it?
That's for Johnson.
Sorry. Do you have the breakdown from Ms. Beatty's testimony?
Clay had it. I talked to him. He said he's got the numbers and he was going to provide them to you for both sides.
As soon as we have it, we'll send it to Your Honor.
It's supposed to be in an email.
Okay. So, what's the way should we do it? Should we deal with the exhibits first and then child victim hearsay?
We'd like to deal with the child victim hearsay issue first. We have Maya here in case there needs to be some testimony from her on these statements. And then we'd like to let her go while we have the rest of the discussion.
Madam Clerk, we're on DIN 3433. Plaintiff's motion to admit child abuse hearsay statements pursuant to Florida statute section 90.802 paren 23. So let's start going through this, and let me ask some questions first so I can understand. I need to know what the statement or statements are that are hearsay that you intend on seeking its admission. And it seems like the first one would be by Dr. Brewerton. Is that correct? Or statements made by Maya to Dr. Brewerton?
Your Honor, I don't believe those are what we're targeting this at. On page 3 of our motion, we set forth 5 exhibits marked for identification, and I can read those to Your Honor if that's helpful.
Well, yeah, I don't physically have quick access to these exhibits.
Sure.
So let's look at the first one, which is 2364.
Yes, Your Honor.
I think someone needs to turn on the screens, Your Honor.
I'm sorry?
The screens, I don't believe the screens are on.
Well, it says you've got a green light, but let me turn it off and turn it back on.
I believe I need to switch it over there. May I?
Sure.
While they're working on that, I have the time. Do you want the shot clock?
What's,
Your
and is it agreed to?
Honor? I believe so.
Okay.
Yeah. For the first video, it was 37 minutes of defense and 32 minutes for the plaintiff. And then for the second video for Miss Betty, it was 46 minutes for the plaintiff and 45 minutes for the defense.
Okay, so what we'll do is plaintiffs will be 30 and the defendants will be 40, and then 45 and 45. which means plaintiffs had an hour and 15 minutes. And the defense had, that's what, 40 and 45. So it's an hour and 25 minutes. So that means the plaintiff's cumulative total is 25 hours, 40 minutes. The defense cumulative total is 9 hours, 35 minutes. Any questions on that, or are we ready to go?
No questions, Your Honor.
Your Honor, I'm flipping back to our original way, so if you wanna turn on my table, I can get us back, because Mr. Cottrell must have configured it a certain way, and I'm not gonna spend too much time with that.
I've already switched it over.
Thank you, sir.
There you go. But wasn't that a problem for the other TV folks of running it through your feed?
Well, until I can get communication from him, I'm gonna just do this now so we don't waste the court's time.
Okay, so you're showing me 2364. Okay, how many pages is this?
Your Honor, this exhibit is 21 pages. This is my special care journal provided to Maya Kowalski during the time that she was sheltered at Johns Hopkins All Children's Hospital. And it is her present recollections at the time, many of which describe the abuse and neglect that she was suffering at the time. I direct the court's attention, if we could, to 2364-010. I direct the court's attention to number 4, blood pressures. Number 5, not getting my pain managed well. Number 8, not getting to see my family. Number 11, having visitors getting kicked out.
Well, let me just stop you here, because normally when we talk about child victim hearsay, it's a statement by, let's say, a therapist that would say, the child said X. This is actually the statements of the child directly. So I'm not sure the child victim hearsay analysis applies for Maya's own journal, assuming that that's what this is.
It's intended for parents.
Am I missing something on this?
It's
I mean, there might be hearsay exceptions that apply for it, but I'm not sure this is a child victim hearsay question.
Well, if we're on this one, it looks to me, again, to be an 8033, as much of our stuff is then existing mental, emotional, physical condition, documenting how she's feeling, what she's feeling, why she's feeling it. And these are being documented at the time. They are confirmable by the testimony of Maya Kowalski, indicating that's an indicia of trustworthiness. They are relevant and material, obviously, to what she knew was happening to her at the time. It was according to a defense request for her to record that, apparently, although it didn't come out quite like they wanted. This was supposed to be her journal of what a great time she had, although it had things I did not like while I was in the hospital. So there's, I guess, both sides to it, as all what evidence does. It cuts both ways.
Well, who gave this to Maya? Let's just start there.
The hospital did at the start of it.
And did she, and I know if I need to get testimony, I can, but did she fill this out while she was in the hospital?
Yes, sir.
And at that time, when when did you fill it out? During your stay?
Well, before we, I mean, if we're gonna have her, I'm gonna need to have her under oath and all that good stuff. I'm just trying to understand what framework I need to be looking at this at. That's the purpose of my questions, not for a factual basis.
Unless I need to be corrected on this, but this was given to her at the start of her stay, and it was not directly a chronology, but there are different pages that, as she stayed in the hospital, she filled out about the events, but mostly, from her point of view as a 10-year-old, how she was feeling about things and what her physical condition was and the emotional state she's in. So if the court looks through them, I think you'll see that although there are some, like it says, some foods she doesn't like, but most of them are about her physical condition, what she likes and doesn't like, and her emotional state.
I'm looking back at the statute. Actually, I don't see anything in the statute that would restrict it to only statements made to others. The statute seems to be a little bit more broad than that.
That was our conclusion.
It's generally you see it with a statement made to, like on a CPT video, or some type of statement to a therapist or a parent or something like that. And okay.
Although we can bring it out, I am fairly certain that this was intended by Maya to document what was going on at the time with the hope that her mom or dad would eventually see it. And I can elicit testimony to that effect.
So perhaps, and it does seem like now that I'm looking at the statute, that this could qualify under child victim hearsay, might also qualify under other exceptions as well. So who's from this side of the room going to be talking about?
First of all, I think I agree with you that or your initial take on 23 is that statute is designed for statements that are made by a child, typically to a police officer or to a therapist or to a neighbor or a family member, and you're calling upon that person to put it in. The reason you're doing that, the reason this was created, was because you have a small child who either may have forgotten or may have been intimidated, or there was some reason why the child, while available to testify, that the quality of the testimony was going to be impinged. And so you put on the hearsay because it's actually maybe more reliable than what the child will take from the stand. That's normally in a criminal case. The only civil cases I've ever seen this used before, by the way, are DCF proceedings and Jimmy Rice proceedings. I don't think I've ever seen this in a true civil case. And I have never ever in any of these things seen it when someone is 17 and a half years old and more than willing to get on the stand and provide competent testimony now about these things in the past. So I don't think this fits into Chapter 23 very well. And then if we get into state of mind, we can go, through the details of this. But that's supposed to be a statement about a then existing state of mind, an emotion, or a physical sensation, including an intent, a plan, a motive, or design, a mental feeling, pain, or bodily health. And it's got to be something that is relevant to an issue in the case, or to be something that explains subsequent conduct, not by any other person other than by Ms. Kowalski. And I look at these things, and they really don't seem to fit into that particularly well at all. These are just very generalized statements. She didn't like blood pressure. Okay, she didn't like blood pressure.
Well, let me just look at one more thing and then come back. mean, I agree with you, Mr. Altenburn, that, you know, you normally see it, like I said, in some type of someone else testifying as to what the child said. Now, I have dealt with child victim hearsay in civil cases before, and I think my last order in that was like 14 single-space pages dealing with it. And I also have dealt with it, you know, on the family law bench several times, and of course, when I was on the felony bench, way too many times. But I've never seen it used for the declarants like a journal. And the statute says circumstances by which the statement is reported indicates a lack of trustworthiness. So I guess the question is, does that mean it has to be to someone else, or is a statement made that by the declarant, the child declarant, into a journal? And I would, and just looking at that, I would seem to think that the statute's broad enough to allow it to also include statements in a journal. So for my purposes, I think we can view this under a Section 23 analysis if we need to, but
And the only thing I'd point out is that once you go through Section 23, then you got to go back to the rest of the hearsay to make sure it's admissible under another hearsay rule. That just allows it to be considered, but it doesn't need to establish that it's not hearsay for another reason. So if, and Mr. Anderson's pointing out that he thinks it's state of mind is how it fits. And so,
and clearly at this point, it's Maya Kowalski's state of mind that we're talking
correct.
about would
This is-
fit under.
It was her, Maya Kowalski's then existing state of mind and whether it's relevant to some issue in this case.
So as it relates to this particular document, before we walk down the Section 23 child victim hearsay,
I will look at 3, state of
I
mind
mean,
first.
why is this just not admissible under the state of mind hearsay exception?
Particularly since Kathy Beatty just put the issue of how she was doing at the
On
hospital.
an
directly
unknown
on this.
date while she's in the hospital.
Well,
She
we have
says-
narrowed the date.
Okay,
It was given to her apparently on video. Our paralegal tells us during the 48-hour recording is when she was delivered this journal.
Okay. Things I did not like while I was in the hospital, not seeing family. Okay, that's a statement of fact, that she did not like seeing the family. Does did that explain her existing state of mind on the day that she wrote this? Does it show her emotion or a physical sensation on that day? Is it a statement of an intent, a plan, a motive, a design, mental feeling or pain or bodily health? She's just saying that she didn't enjoy the fact that she didn't get to see her family in the hospital. That if that fits that description, practically any opinion about likes and dislikes becomes admissible as a state of mind exception. That's clearly not what this statute is designed to allow into evidence.
If you're being neglected at the time as a 10-year-old, yes.
I was just going to make that point. I mean, we're talking about a 10-year-old child who is asked what she didn't like. And isn't this the means by which she is expressing those? I mean,
Yes,
yeah,
I mean, that she
I haven't
didn't
seen
like
the other
that.
pages, but is there anything in the other pages that are problematic from any side's perspective?
I haven't gone through every single one of these pages, John.
We can cycle through them. Some of them are pretty innocuous, and perhaps the hospital wants to use them. So,
She doesn't like some foods.
and she also likes some things. So
Yeah.
we're
It's
willing to
painful.
put the whole thing in.
I just, she can get on the stand and explain all of these things. It's not like she's 8 years old and forgot it all.
I mean, clearly she could use it to refresh her recollection without any problems.
Correct.
Can we just cycle through the pages and let me see what's in there?
Would you like to start at page 1?
Just start at the beginning. So the point was to express her thoughts and feelings. Okay. The next page, please.
You can tell me anything that was in your heart.
Okay. Next, please. Okay. Thank you. Next. You remind me who Corrine is?
Her older stepsister.
Oh, that's right.
Half sister.
Next page. Next. And the next. We saw that one. The next page. And the next one. Next one. The next one. Next one. Can you turn it? Next one. Next one. Next page. Next page. Can you? And the next page. Next page. And the next page. So, I'm assuming that.
But yes, as to the hearsay, yes, Your Honor.
It would need to come in with a limiting charge that's being limited for purposes of not the truth of the contents, but for the child's state of mind at the time it was prepared.
No.
That is made clear in the standard jury instruction. And the more special instructions we give this jury, the more chance of inconsistency and confusion.
The following
Well-
document is being introduced to prove the state of mind of Maya Kowalski at the time of her stay in the hospital in October, whatever these dates are. It is not being introduced to prove the truth of the factual statements or the accuracy of the opinions contained in the document.
Well, then we're gonna have to do for.
Time out.
Sure.
It would seem to me that you can use child victim hearsay substantively without limitation if it comes in. So, in my mind, it certainly falls under sub 3 for then existing mental, emotional, or physical condition. And I think it also could qualify, although technically we'd have to have the hearing that was necessary to admit it. But if it comes in under sub 23, I don't see why I would have to give any type of limiting instruction. I mean, does Professor Padovano
You're
say
correct that
otherwise?
If it goes through both hoops and it gets to 23, that's substantive evidence that she doesn't like food.
So,
It's substantive evidence of the statements of fact in it. That's what it is.
so if we would probably need to do the hearing as to that one. Because that sounds like they want to use it for substantive evidence.
keep in mind, it needs to be a statement of the child victim describing an act of child abuse or neglect. So you have to find that these things are child abuse or neglect because they're not criminal offenses. I think giving her bad food is not child abuse or neglect. It's hospital food.
Well, it's not limited to just that.
I know, I'm just,
And it has to be read in context.
So it sounds like we'll have to have a hearing on that one for whether it would qualify or not. Okay, what's 2365, Exhibit 2365, what's that?
This is a statement taken down. These are statements of Maya Kowalski taken down by her father, Jack Kowalski, at the time, in which she's informing him of different instances of abuse and neglect.
I'm sorry, say that one more time.
All right, this is a writing of Mr. Kowalski. So he is recording what Maya Kowalski has relayed to him during one of his limited visits regarding the abuse and neglect by the hospital, and in particular, Kathy Beatty, in the hours and days leading up to his visit.
Okay, so this is more of the classic child victim hearsay type statements. Is there any other basis, hearsay exception that the plaintiffs allege this falls under?
Well, it is again, and many of ours are a 8033.
It would also be 8034. Some of these would fall underneath statements made for medical treatment or diagnosis, keeping in mind that she's a 10-year-old child, and she's relaying for example, that she's not getting any medication, so she's trying to seek medical treatment.
To her parent or guardian to relate. So this is the way she can relate at 10. To relate the medical information through her guardian to the doctor.
this is a document explaining by her father that she has brought up. She brings up these issues without me extracting this from her. He's not purporting that these are actual statements made by her, and then the very first one is hearsay upon hearsay. Kathy informed Maya that her mother, Beata, is getting mental treatment.
Yeah, qualifies as admission.
Well, clearly, the child victim hearsay would be what Mr. Kowalski testified that Maya Kowalski said.
Correct.
But this does look like it.
That
We
doesn't
would
put
need
the
a hearing on
document
it.
in as compared to his testimony.
Yeah.
Can you redact his phone number real quick? He might get a number of text messages.
Okay. What's the next one?
The next one is akin to the first, which would be writings by Maya Kowalski while in the hospital describing events of abuse or neglect. Well, excuse me. 2365 had several pages, Your Honor. So there's 4 relevant pages, 2365. So we should probably show you the rest of that one.
Okay, let me see the rest. And it might be, okay. I think to be accurate, it's not that this document 2365 would come in. It would be Jack Kowalski's statements as to what Maya Kowalski said. He could use this to refresh his thoughts, but it's Jack Kowalski's statements as to what Maya said. That would qualify under Section 23.
Not the document.
Not the
itself.
document.
Okay, if the court is saying that if she had made the statements to a therapist or detective, that the written report of that therapist or the progress notes of that therapist would not come in.
What normally happens is the therapist comes up and testifies. the child victim said X, Y, Z.
Understood. So that would only apply to page 1 of that exhibit because those are Jack's present recollections. However, 2, 3, and 4 are, again, we're back to Maya's writings.
I think this is the one we talked about the other day, referring to this was done at the request of an attorney.
It was done
It
for
does say attorney at the top, but there's no evidence that we're aware of that the attorney requested this. This is,
Well, I think I'm going to need testimony as to the balance of these pages. I'm not saying it is or isn't child victim hearsay. I'm just saying I'm going to need testimony on that. Okay, what's the next one? 2366.
and 23661 looks to be,
the same
yeah,
document.
it looks to be redundant. It's,
So that's the same as 2365?
it's 23666 is one of the pages that is part of 2365, so I think we could ignore 2366 and 2367 because they are both part of 2365. Which I believe leaves 2380.
2380. And what is 23? Can you put up 2380, please?
So 2380
I don't have
is
that.
effectively Jack Kowalski's notes, both handwritten and then his process was to, when he returned home, to type up some of these notes. And it's, again, back to statements made to him, and he's recording what Maya has relayed regarding the abuse.
Well,
of the book.
show me, because the first one looks like a discussion with somebody from DCF. So show me where he's talking about statements that Maya made.
For example, in the second paragraph, October 27, 2016, she requested communion. So that'd
Mr.
be
Reyes, can you highlight whatever Mr. Whitney's talking about?
the last sentence says she requested communion. That'd be a statement of Maya Kowalski.
Well, that one I think is going to have more difficulty falling under child victim hearsay because Mr. Altenburn's right. There still has to be, for child victim hearsay, it still has to be grounded in some type of wrong that is more criminal in nature.
Understood. Let's turn to 2380, page 8. And this is the last part there, Friday, January 6, 2017. It describes the improper photography session by Catherine Beatty as relayed from Maya to Jack.
Well, again, this one would, if it met the reliability test, the content of the conversation between Maya or Maya's statements to Dad potentially could fall under child victim hearsay, and especially since this one actually involves a battery, an alleged battery. I think this one could be, so we would need testimony under child victim hearsay. Mr. Altenburn, any contrary thoughts?
And my only confusion too is that it's dated Friday, January 6th, but the last part is upon her return to All Children's Hospital, Catherine instructed her to remove her clothing and take photos again, which she could not have told him that on January 6th. I don't know.
She absolutely could have. She went to court. And came
These are
back.
things you can bring out on cross-examination. I still have to find trustworthiness and all those other things. It's just, I think this one is something that we could have here. So it seems like we're going to need a hearing on number 1, number 2, and number 5.
I'm sorry, when you say number 1, you're talking about 23.
On page 3 of the motion,
Oh, I'm sorry, I don't have the motion in front of me.
yeah, it looks like trial exhibit 2364, 2365, and then 2380. Now, as it relates to those last two, it's not to put in the actual exhibit. It would be to allow Jack Kowalski to testify as to what Maya said.
Understood.
Okay. Now, and thinking about number one more, it does. I'm more confident now, just kind of thinking about it a little bit more, that there can be some sort of journal entry that would qualify as a child victim hearsay, so long as you can show the other components of the statute. So, do we want to go ahead and have your witnesses? Is Jack Kowalski here?
I'm deciding him.
You were blocking him. So let's go ahead and have the child victim hearsay hearing and call whatever witnesses you want or need.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Your Honor, just to save time on the journal, so long as the whole thing goes in, to save time, we'll just agree to let the whole thing, you don't want segments.
Well, I think that's what Mr. Whitney said is they were fine with putting the whole thing in. So at this point, are we, Mr. Whitney, I think this is what Mr. Altenburn, I think, is saying is they're okay with the entirety of 2364 coming in, which is number one on your list.
Great.
Okay, so the court will receive 2364. That's a completed issue, and now we don't need to worry about that.
State your name for the record.
Jack Kowalski.
May I approach with 2365-001, Your Honor?
Sure. Can we publish it?
Just put it out on the screen. Oh,
Want me to turn it?
yes, and actually put it back down on the ground. Sure. But let's not make it on the cord.
Okay. Does it go on?
Well,
Oh,
yeah,
right
yeah,
there.
there you go. Awesome. Well, you still have another cord under it.
Okay.
Thank you.
I believe it's that the feed, the video TV feed is gonna be able to pick up the exhibit.
I just switched it, so you tell me if it's fixed.
I will let you know. Flip it back.
I'm breaking technology left and right, aren't I?
Fine, you're doing great. You can put it back the way it was.
I told you I'm not a TV director. Mr. Anderson, you may proceed, and Mr. Whitney wanted the exhibit 2365. What page, what, number one was it, Mr. Whitney, that you wanted up?
One, Your Honor.
Yes, sir. 2365-1.
May I please, clerk?
Yes.
Please state your name for the record.
Jack Kowalski.
Where do you live?
I live in Venice, Florida.
Are you the father of Maya Kowalski?
Yes, I am.
During the time of her stay at Johns Hopkins All Children's Hospital between October 7th, 2016 and January, I think, 13th or 14th of 2017, did you visit your daughter frequently?
Yes, I did.
And during those discussions, did your daughter relate to you certain unsettling or troublesome issues regarding the way she was being taken care of?
Yes, she did.
And did you then, at or near the time, record these in a note for future reference and memory, and to point out the different abuse and threatened abuse against your daughter?
Yes, I did. I documented every time I went for a visit.
And is this trial exhibit 2365-001, was this completed at or near the time of a visit?
Yes.
Do you recall approximately when?
I usually jotted it down on a piece of paper and then I would type it when I got home.
So this is the typed referral of it.
That's correct.
And in this, did your daughter state, among other things, that she was scared to talk to the judge in court because she was worried about...
Mr. Anderson,
Yeah.
I'm going to want him to testify as to what she said. I don't want leading as to what she said. I think
Right.
I cannot have leading on this one.
I understand. What did she tell you at the time that you recorded this?
Well, anytime she felt there was a problem, she would tell me or write it down on a piece of paper.
And was she coerced in any way, or was this voluntary?
No, that was all voluntary.
And this is offered? Was this offered? What was the word I was looking for? Sorry. Was this volunteered?
She initiated it and gave it to me. She wanted me to know.
And can you relate what she related to you as best you recorded it using this to tell us?
Yes.
In terms of, and I know there's a lot there, but in terms of abuse, neglect.
How she would tell me, or I'm
Just
sorry.
What she would tell you.
She would tell me, if there was a problem, how she's being treated, things like that. And then also she would write it down on a piece of paper and give it to me also.
What were the types of abuse that she told you about on the visit that resulted in this recording?
Okay. I could read a couple here just to give you an idea.
Sure.
Well, I need you to tell me what she told you.
Tell us verbally what she told you that prompted you to go home.
She was stating that she was having issues within the hospital that she didn't agree with, that she felt that they're not doing appropriate things.
And can you describe more the inappropriate things that she was doing that caused you concern that your daughter was being abused or neglected?
Yes, there was incidents where the social worker was hugging her, kissing her, making faces while mom was on the phone with Maya, the supervised phone calls. She would make expressions, things like that. The social worker, she told Maya that mom's in the hospital getting mental treatment. There was a doctor, I believe it was Elliot, stated that mom was put Maya in comas every week at home. And it went just on and on. I mean,
what, if anything, did Maya tell you about her need for medication and what doctors informed her concerning that need for medication?
I can't have leading at this point.
What, if anything, did Maya relate about her need for medication?
Well, there was an incident that I could remember. The doctor said it was all in Maya's head, that she didn't need medication. It's hard to remember all these.
And what, if anything, did Maya tell you about her need?
She was in pain.
Conversation about her need for medication.
She was in pain. She needed medication.
Move to admit.
Yes, and then I'll probably have questions, so go ahead.
Well, if Your Honor has questions first, you're welcome to. I didn't mean to cut Your Honor off.
No, I'll wait till after you're done, because if you cover what I'm gonna ask, then it's better for you to do it.
Good afternoon, Mr. Kowalski.
Good afternoon.
That you had testified a moment ago about having a visit. What date was that visit, sir?
I would have to look at the document. I don't know the exact date now.
Okay. The description you had of Maya telling you that someone was hugging or kissing her, do you remember what date that was?
I have a journal that I wrote in, and that was all my notes were turned in to my attorney, and I believe you have a copy as well. And that does have the dates of all those incidents.
The discussion of people making faces at Maya, do you know at what point in the hospitalization that was?
It's within my notes. I do not know the date, top of my head.
The discussion of the doctor disputing whether Maya has pain, do you know what doctor that was?
No, I do not on that.
And what's marked here for the court as PLT 03 4197, would it be true that you do not have an approximation as to when you generated those notes?
Not at this time, I do not, no. But like I said, you could find all the dates within that journal that I made up. You will find all the dates.
I appreciate your time, sir. Thank you.
Did you bring that journal with you, by any chance?
I do have mine, yes.
May we approach
It's in my
May
bag.
Refresh his recollection.
If it refreshes his recollection, that's fine. Now, before you show it to him, you gotta show the defense.
This has been previously produced on numerous occasions and used, I
Let's
believe,
just show it to the
deposition.
Well, which note? These are not his.
Some are his, some are not his. I'm going to have him turn to those that are either typed or in his handwriting.
Respectfully, I still haven't seen a note that you placed. There's a book of several hundred pages. Most of those are not his writing.
He has testified previously that he took handwritten
I
notes.
have to
and
interject
typed
because it's leading on this issue.
What we're talking about at this moment is refreshing the recollection. And that's all we're talking about. And pretty much he can look at anything if it's gonna help him refresh his recollection. Now, certainly you can look at whatever's being shown to him. And then you'll be able to ask him questions about it, but perhaps if that's his journal or something he has compiled, perhaps it's best for him to figure out where in there we're talking about.
Right. I'm very well aware of the broadness of refreshing witness recollection. What was handed to me looks like about a 400-page notebook, of which in skimming it, none of it is his writing.
Well, here's his writing, so that's inaccurate.
Well,
And that's why we said we were going to have him identify it.
All we're trying to do is right now figure out the date. Mr. Kowalski says it's in his journal. So let's show him his journal and let
Jack figure it out.
Mr. Kowalski figure out what we're talking about as far as the dates. And then we can show everybody the specific page or
I see what you're
pages.
showing him before you refresh his recollection. And you're representing the court that that's his handwriting?
I am about to, if I can ask the witness. May I approach, Your Honor?
Yes, but let him figure out. All we're doing is giving it to him. You don't need to ask any questions. Let him figure it out.
That's my handwriting.
The issue is, you said that you needed your journal to
Yes, sir.
remind yourself of the dates, so
Okay.
let's figure that out first.
It's going to take a while, just so you know. Sorry.
I have a suggestion. Since the other two will likely require the same thing, may we have the witness go through them and we can then move on to 2 or 3 other matters in the interest of time, or you want me to
I
wait?
want to address this issue first.
Yes, sir. No. I gave it to him too. Mr. Kowalski, given the statements made within there,
Time out. No questions. Let him figure out the issue of the date.
Okay. Let's see. That's not it. I didn't really look at this list. Do you want me to compare it to the, or just come up with some of them? I mean,
You said that you needed to look at this journal to remind you of the dates that Maya told you the statements that we
sure.
that you just told
Okay,
us about.
I got some handwritten notes from her. I'll go to that. I'm sorry.
Mr. Reyes can tell you the issue that's going on.
A lot of pages. It's in here.
So court IT to the rescue. Thank you.
Okay, I found her notes. There's no dates on them, so I'm sorry. I'm going to go back and keep looking and see when those were from. I don't know exactly what's on here, but I mean, okay, here on let me get the date. Here, Friday, December 2nd, 2016, PLT 035171.
Friday, December what?
I believe it was December 2nd, Your Honor. Let me check. Yes, 2016.
Whatever page you have that refreshes your recollection, why don't you just show Mr. Shapiro and Mr. Anderson that specific.
This is one of them. I'm sure there's more.
Come on down, Mr. Shapiro.
Thank you, sir.
You want me to keep looking for more? Or?
I think for now, no. Let's
Okay.
just keep going, Mr. Anderson.
Have you had your memory refreshed as to a day? Strike it. Did Maya keep reminding you through the course of your?
Object to the leading of that.
You can't have leading.
How often would Maya remind you once an incident happened?
Same leading, Your Honor.
How
Roll
often?
that one.
She would state several times on certain, occurrences or episodes in reference to her phone and things like that.
And so, have you determined a date when the majority, if not all, of these in the submitted exhibit were related to you?
I don't. I'm sure it was various dates, but I do not recall the date on this this piece of paper here.
What, if anything, happened on Friday the 2nd in 2016?
There was incidents on that.
And did you record that at the time?
No, not on those.
How do you know that there were any of these taken down, these notes taken down as of Friday the 2nd of 2016, the date you had previously given us?
This was in my journal. I just documented. I had a problem from the first visit. We drove up there and we were denied, and that was an hour to travel up there. We were denied, and I didn't want to cause problems, so I just kind of bit my tongue and went home. And I figured by documenting, that's how I started documenting everything.
All right, so in terms of what's written on the exhibit and your handwritten notes, can you identify for the court whether those notes were transcribed, doesn't mean to be all, but those notes were transcribed on Friday the 2nd, 2016?
Yes, Yes, that is correct. Whatever date it was documented, that's the date it happened, yes.
And it was your routine practice to
Object to the leading.
Sustained.
What was your practice regarding these notes to make them clearer and more legible?
There's times I wrote it on a little piece of paper. As you could probably see on the first page, that's when it first started. They were just tiny little, could I hold it up or no?
If you want to.
Okay, just tiny little pieces of paper. So and by just scribbling on there, it's hard to read, and probably later on I wouldn't be able to read it. So I would type it out and then date it.
And did this, did this become your practice as time went on with these notes?
All the time, yes.
And did it become a routine for you?
Each and every visit.
Questions, Your Honor?
Mr. Shapiro probably has questions.
If I understand your testimony, sir, the document that we've been provided seems like a compendium of different things that you've retyped from various aspects of your notes over time, true?
True.
Okay. And just to be clear, the exact date of the exhibit 2365001, when that was prepared, in fairness, you don't know the date that was prepared, true?
That most likely is true, yes.
That's all, thank you.
Okay, thank you.
Now, let me ask you a series of questions. So, what I wrote down as far as the statements that you are relaying to us that Maya told you, and this is in regards to 2365 and 2365 only, was one, that a social worker hugged and kissed Maya and made faces when Maya was on the phone. The second statement would be that the social worker told Maya that Maya's mom is in the hospital getting mental treatment. The third statement that Maya told you is that Dr. Elliott told Maya that her mom was putting Maya in a coma each week. And then the fourth one, and my notes are a little unclear, so correct me if I'm wrong, is that I think you said Dr. Elliott said something to Maya that all of these items are in Maya's head.
I believe it was Dr. Elliott. I could be wrong on that. I could go through my notes and find it.
Well,
but yes, I made these notes after her talk.
And the December 2nd date of 2016, is that the date when Maya told you these 4 statements, or were these 4 statements told to you at other times?
Those would be the day that I was notified.
Well, you're saying passive voice. When did Maya tell you?
On that date of visit.
And tell me about that date of visit. What was going on? Who was present? Paint me a picture, if you will.
Maya liked going out of the room as much as possible because she was in there all day, confined to that. A lot of times we would go down to the lobby. She would play piano, go to the rec center when she was physically able or, had the strength. Sometimes just going in the hallway or just going to get some food down in the cafeteria. She would bring things up.
And was there any supervision of your visits on this December 2nd date?
I honestly couldn't tell you from the top of my head.
Do you have any recollection as to, besides you and Maya, if anyone else, when I say was there, was within earshot of your discussions with Maya?
No.
No, there wasn't, or no, you don't remember?
No, there wasn't. I believe there wasn't.
And Maya was 10 at this time?
I believe
Or
so.
just about ready to turn 11?
December 10th is her birthday, so
So she was almost 11.
yes, sir. And Your Honor, all these notes were produced to Deborah Salisbury when that all took place.
That's fine. Right now, I'm just trying to
Okay.
get at what you remember. Okay. Is there anything else, and I'm going to turn it over to the lawyers for additional information from this witness about this issue, and then we're going to move on to the next one, which is 2380.
I think it would help. I knew what which issue the court would like me to pursue.
Well, right now we're talking about the statements that Maya allegedly made to Jack Kowalski that are encapsulated in your Exhibit 2365.
What, if anything, did Maya tell you about Kathy Beatty?
Number one, she did not like her.
What else? Tell us everything you can remember that Maya told you on this date about how Kathy Beatty treated her.
Well, like I said, there's times she made smirks in front of Maya during the phone conversation. She stated that she placed her on her lap. I never gave consent, by the way, on that. She stated that she used to come in, slap her leg to see if she was in pain. She said that she wanted to adopt her, that her mother was in a mental home, so she could be like her mother while she's in the hospital. There was a time that Maya was on her school computer. She said, "You're probably searching sex websites." She's a 10-year-old girl. I don't think they would know how to go on there. I know Maya was upset about the dress, missing, and that ended up being Kathy's office.
What, if anything, did Maya tell you about?
Oh, I'm sorry. Well, then we had the pictures. Maya told me that if she didn't get the pictures, she was unable to go to court, according to Kathy Beatty.
What else did Maya tell you that Beatty said about going to court?
She was scared. If she challenged Kathy, she was scared that she would not be able to go to court.
What, if anything, did Maya tell you about the hospital and what she did not like about it in this conversation, as you recall?
Well, number one, she didn't get her treatment. She was distant from her family, and it was difficult to communicate with her family, including going through her lawyer. You know, it sounded like there was, you know, she was scared. And she wasn't getting the proper treatment, so.
May I approach?
Stop.
It's a minefield here. May I approach?
This one. Didn't really read it.
What, if anything, did Maya tell you about attempts to stand her up out of the wheelchair?
What did Maya say to Kathy?
No,
Or
this
not?
is in general.
Well, number one, she couldn't stand up. There was a time, one of those third
I'm
party.
sorry, Mr. Anderson, I need the statements that you are trying to admit under
Right.
child victim hearsay that Maya made to Jack Kowalski. That's what I need to focus on.
I understand. What, if anything, would the nurse do when the phone rang insofar as observation of Maya?
Number one, the phone was moved far away from her bed. It would ring. And,
Mr. Anderson, maybe we're not communicating. This is statements that Maya made to Mr. Kowalski. I need to know the specific statements that Maya said to Mr. Kowalski and the circumstances surrounding those statements.
What did Maya tell you? And what was the context regarding the way the nurses responded to the phone ring?
I object to the leading again. Your Honor.
Sustained on the leading.
What, if anything, happened on this date insofar as Maya relating to you an incident with, what did Maya say about the phone?
It's still, I apologize, it's still leading, Your Honor.
I agree.
What,
Yes, that was a leading.
what else did Maya tell you that day?
There was a time she reported the phone did not work. I did take that to the attention to one of the nurses, and like after a day, I believe it was fixed. But a lot of times the phone was far away from the bed.
I think that's all that covers it, Your Honor.
Since you're up, and so we are not doing it, is there anything else that you want to address with respect to Trial Exhibit 2380, which is number 5 on the motion?
One final series of questions. Where were you when these statements were made by your daughter to you?
Within the hospital, like I said, it could have been in a room, it could have been down in a rec center or a cafeteria, things like that.
Your Honor, were you referencing, should I then ask about the other exhibits as well? Or?
Yes, let's just finish it out so that we can try to bring some resolution to this.
May I approach, Your Honor?
You may.
Or actually, we can put a, this is Trial Exhibit 2380-008. Now, what date were these notes made?
Here, I see Friday, January 6th, 2017.
Look above it, and from what Maya told you, is it true for that part of the memo as well?
No, that would probably be another date up above.
Can you tell us can you tell us what date?
Could I look here real quick? It's
Absolutely.
probably, okay. Friday, January 6th.
The top, Mr. Anderson, most likely is not gonna qualify under child victim hearsay. I'm not sure you need to spend time on the top.
Agreed.
The bottom.
Mr. Kowalski, don't worry about the
Okay.
time on that one.
Okay.
On the one on Friday, January 6th, 2017, where were you when, did Maya tell you anything about abuse in that visit? First question is, did she?
She did report it to me.
And so let me ask you then, were her statements voluntary?
It was voluntary on her side, yes.
How soon after did you transcribe these into 2380-008?
I usually did it right away.
Within 24 hours or?
Yes.
And what did Maya tell you on that day regarding any abuse towards her?
I'm trying to find out how this might have been, I could be wrong, but maybe my brother is the one that transported her. He reported it. I could be wrong, but I forgot how this information.
Did Maya tell you this directly?
Not on that day. I was unable to talk to her.
Withdraw.
Okay.
Yeah,
All right.
that was the day of the court, correct?
May I approach as to exhibit the last one, 2380-013? That's it, 2380-013. Actually, you can see it there.
Yes. Okay. Yes, these are what I was talking about earlier.
When, to the best of your knowledge, did Maya tell you about this? And if it's multiple dates, fine.
What's the dates number on this history?
2380-013. Bates number is plaintiff's.
Sir, thank you.
Mr. Anderson, I don't know the date, but I know it is in this booklet, the dates.
Go ahead. If you can find
Okay.
the date, we need the date.
Okay.
The best you can do, judging from what's being said. As you're checking there, Mr. Kowalski,
Yes.
I noticed there are some repeats here. What, if any, of these were, again, told to you on the Friday 2nd, 2016 date?
The Friday, what? I'm sorry.
The Friday the 2nd, 2016 date that you just testified to as to many of these.
$2016, you stated?
What's on the screen,
I'm not seeing the date on there.
I understand.
Okay.
We're trying to establish it.
Yeah.
So, were any of these, because you already testified to many of them on Friday the 2nd, 2016, did Maya tell you one or more of these? What did Maya tell you?
A lot of these were earlier than that.
Okay.
Do you have the scared to talk with the judge?
Okay. What else?
I believe the computer incident was earlier than that. And
It's not so much when they occurred, it's when Maya told you about them. Did she relate these?
Oh, it was before that.
Okay.
Before that Friday.
Can you find us the date before the
Yes.
Friday, December 2nd?
She made little handwritten notes, and that's what I'm looking for. I'm sorry. There's a lot of pages.
Is there any way you can tell us just when the visit before this occurred?
Before, I'm sorry.
Your Honor, respectfully,
Before you took down
Hold on a second,
this,
Mr.
well, before this one?
Mr. Anderson, hold on a second.
I understand the importance of this issue, but respectfully, it appears we're at the point where he's trying to refresh where the statements came from that appear to be coming from Maya's notes, that he then took from Maya's notes and then recorded in a summary later undated. I don't know how this lengthy
That
exercise.
seems to be an argument.
Okay, I
So the
apologize.
circumstances and trustworthiness and all that good stuff.
Yes, Your Honor.
Mr. Kowalski?
Yes,
Let's
sir.
just stick with Friday, December 2nd, 2016. If you look at Trial Exhibit 2380-013, what, if anything, did Maya tell you that was transcribed? What did she tell you in the way of abuse that was transcribed into a document? This one.
Maya stated that Catherine had brought her to the chapel, placed Maya on her lap, and I said, I know I'm not your mom, but I will.
Your Honor, I object.
I mentioned this earlier.
He's reading the note.
I
I
need
mentioned this earlier without reading it.
you, just tell us what you remember she said.
Oh, I remember Maya very upset that Kathy Beatty put her on her lap. I remember her saying that her mom's in a mental home getting treatment, or in a hospital getting mental treatment. Kathy Beatty placed her on her lap, kissed her, stroking her hair, and said that she could be her mom, and then that she wanted to adopt her.
And did Maya state these directly to you, or did you just simply take a note?
No, she told me about it. And the problem with that is if I lose my temper in there, I'm going to lose my privileges. So I had to keep my cool, and it was very difficult to do so.
And again, would Maya repeat to you incidents that had happened earlier in this Friday, December 2nd, 2016 date visit?
Yes.
Anything else you can remember her stating that might fall within 2380-013. And then just tell us what she said.
I mentioned about the computer.
All right, just take it in. All right,
Yeah, right on the top of my head,
all right.
I'm sorry.
Substantially the same as what you've already told the judge she told you,
Yes.
your witness. And again, was this voluntary?
Yes, it was.
And was it your routine to transcribe these at or near the time?
Yes.
Your witness.
Mr. Shapiro, any?
I don't have any further questions. Thank you.
Your Honor, I would just like to point out in the legal analysis.
Can I ask a couple questions first? Just,
Absolutely.
I want to finish the testimony and then we can talk about it. So, I guess the additional statements that I wrote down in my notes that you contend Maya told you, was that Maya told you that, was it Catherine Beatty told her that her mom was getting mental treatment?
That is correct, Your Honor.
And it was Catherine Beatty, Maya said it was Catherine Beatty that told Maya that she, being Kathy Beatty, wanted to adopt her, meaning Maya.
That is correct.
And Maya told you that.
Yes, sir.
And did Maya also tell you that it was Catherine Beatty that questioned her and made the statement about this using the computer and are you on like a sex website or something?
Yes,
like that?
Your Honor. Yes, that's true.
And you also said that Maya said, and I just want to make sure that Maya told this to you as opposed to someone else.
She
Did Maya tell you that Maya was scared of challenging Kathy Beatty?
Yes, she.
When did she tell you that?
I don't know the date, sir, but she was very scared of her. She did not like her.
And how about the statements about not being able to come to court if she didn't comply with Miss Beatty's statements? Was that to you?
She did say that to me in time. I don't know
And when
when.
you say in time, was that,
Well, it wasn't on that date.
it doesn't matter if
Okay.
it was on that date, but tell me, to the best of your memory, sitting here right now, when she told you that, and tell me the circumstances of those discussions.
I honestly could not tell you the date or approximate date.
Try a
But,
month, Jack. Sorry.
She did. She brought that up many times.
And has Maya told you about the photographing issues?
She did.
Tell me the first time, if there were more than one, tell me the first time Maya told you.
I know it was when she was still in the hospital. That would have been after that date. I don't know the exact date, but we were informed of it.
Don't say we were informed. Tell me what Maya told you.
Maya told me that she was held down by an individual, and Kathy Beatty said we have to take these pictures before you go with your Uncle Scotty. That's the brother that transported her from Johns Hopkins All Children's Hospital to the courthouse in Sarasota. Maya stated that she did not want her to do it, and she basically said, if you want to go to court, you have to let us do this. Maya said it was very disturbing.
And the first time that Maya told you this, who else was present?
I honestly don't know. Usually it was myself visiting or with Kyle, but I don't believe Kyle heard that.
And was this before or after your wife died?
That would have been before. I'm sorry. It might not have been before. If this was on the 6th. You know what? It could have been. It could have been.
Defense, any further questions?
No, I would just point out to the answer is no.
Okay. Any further questions for this witness?
Just one. Jack, that last question from the court was perhaps a bit vague to you. The photographing incident, was that before or after Beata passed away?
Well, that's what I was trying to think. The court date was on the 6th. I'm trying to think if I visited her on the 7th. That's what I'm trying to figure out. If I visited Maya on the 7th, well, I could look real quick if you don't mind. But it may have been after. I honestly don't know offhand right now.
Was the photo? So you don't know as you sit here whether or not the Maya's direct report to you
I believe it was after.
after we say after Beata's.
I
passed.
believe so. Because I would have to look, but it sounds about right.
But I heard you earlier say,
I
but
object to the leading, Your Honor.
Just go ahead and answer.
what was?
Ask the question.
But it was reported to you while Maya was still in the hospital.
Oh, yes, it
So-
was.
Is it your testimony then that would have been reported to you sometime between January 7th
And the
and
13th.
the 13th?
Yes.
Thank you.
Anything further?
No, Your Honor, thank you.
Okay, Mr. Kowalski, you can go ahead and have a seat.
Thank you, Your Honor.
Did you have any other witnesses that you wanted to call with respect to the child victim hearsay aspect?
We have Mike Kowalski, Your Honor.
Yeah, and you can have a seat. Now, to be clear, what we're talking about right now is child victim hearsay. It's not, I mean, Maya's most likely going to be able to testify to all of this before the jury. It's just whether we get the testimony of someone else as to what Maya told that person.
No, Your Honor, the only person would be Kyle, and he was very young at the time.
So are you going to want to call Maya Kowalski now, or are you?
I think we're okay based on what her knowledge would be at that time outside of what she would testify to.
Okay, arguments now. And so, I don't know, do you want plaintiffs, you want to go first?
Sure.
Since you're the proponent here?
Yeah. We have numerous indicia of trustworthiness. Go ahead.
Your Honor, with respect to Jack Kowalski's testimony and credibility, he has provided several affidavits, declarations in this case, deposition testimony. Never has his credibility been questioned. Under question here on these particular documents, he was able to refresh his recollection based on his contemporaneous notes. I want to point out that with respect to 2380008, which related specifically to the incident of the photography, he was honest and credible in that testimony because he testified that on the first instance, this was told first to his brother, and he was honest about that. Then, when asked a few questions by the court, he testified specifically that he was told in the hospital within a week time span. If you look at 2380008, there are details that he provided in his testimony that are not within the paragraph Friday, January 6, 2017. Specifically, Mr. Kowalski testified that Mike Kowalski was held down by an individual while Kathy Beatty photographed her. That detail of a nurse holding her down, separate and apart from Catherine Beatty's efforts to photograph her, is not included in what was used to refresh his recollection. So that's an additional indicia that he was remembering details when prodded that were relayed to him directly by Mike Kowalski. So we would ask that the documents be admitted or used to refresh recollection under the child abuse hearsay exception.
Let's have it admitted first.
Your Honor, for clarity, we're only discussing whether or not it's going to be used to refresh recollection. Is that where we are at this point?
No, we're talking about the statements that Maya Kowalski told to Jack Kowalski
Right.
under the child victim hearsay generally or statute. That's generally what we're talking about at this moment.
For their introduction or for their use to refresh his recollection? That's what I'm trying to figure out.
For substantive
For
evidence.
substantive evidence, okay. And so, first of all, you need to understand that this is a two-step analysis you're in right now, because this is not a case where there is a cause of action or a claim for child abuse. And so you have to find that a statement was a statement describing an act of child abuse, and that statement is then relevant to an issue in either the battery or maybe the false imprisonment, possibly the medical malpractice, or intentional infliction of emotional distress. And while using the photographs is probably their easiest example, is that does relate to one of their alleged counts of intentional restraint and battery, and so those at least cover part of that issue. But many of these things that they're talking about, that Kathy Beatty told her that, first of all, that she was afraid of Kathy Beatty and didn't like her. That's just not a statement of child abuse. That she wanted to take her computer away, apparently because she was worried about use on improper websites. Again, I don't believe that's an act of child abuse. There are several other statements that they've gone through here that if you look at them and say, is this an act of child abuse? It may be something the child doesn't like. It may be something that's discourteous, but it rising to the level of something that's admissible because it is a statement of child abuse. Many of the things that you've just heard there did not fit into that category. So if you're going to enter an order, in addition to going through the requirements of the statute under subsection 23 to make it admissible, you have to find that it is an act of child abuse and that it would be relevant to an issue in this case. And I believe that there's a very limited scope of these that might possibly be used in that fashion.
Well,
Just
I think I understand where you're going, Mr. Altenburn. Did this side want to say something else?
very briefly, Your Honor, just to add on to my colleague's argument on the law, in terms of the factual declaration given by Mr. Kowalski, he was quite honest with this court that he does not know when these notes were prepared. He was asked that multiple times. He does not know when many of the statements were made to him in terms of dates, in terms of where he was. He is not able to identify in some of the statements what nurse made a statement or what doctor made a statement. So it goes to, the reliableness and the veracity in order to be able to analyze whether the statement could come in as a hearsay exception as well. Thank you, Your Honor.
I think Mr. Kowalski testified credibly that the statements, with the exception of the photography, were given to him, made to him by Maya Kowalski on December 2nd, or perhaps within the 12 hours, 24 hours preceding that, because he had a process and routine of taking her statements and recording them contemporaneously. The fact that Maya related several incidents to Jack Kowalski that may have occurred on various dates on a singular date does not make them fall outside the statute. With respect to the legal argument about findings of child abuse or neglect, I would point out that 803.23 not only includes child abuse, but also includes child neglect or sexual abuse or an unlawful sex offense on or in the presence of the child. Child neglect under the statute is a caregiver's failure.
Are you talking about 827.03?
I am, Your Honor.
That was going to be my next question to both is, since these terms were not defined in 90.803 paren 23 paren 8, do we look to, in this case, 827.03 for the definition, or is the definition in 90.803 paren 23 paren A something else?
From the defense side,
Well, that was just I'm going to want to hear, but Mr. Whitney is.
As an undefined in the statute, when I say the statute, 803.23, we would look to 827.03. There's both a definition of child abuse. I'm going to focus for a moment on neglect of a child, which is a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, which the defense is focused on, nutrition, clothing, shelter, supervision, medicine. There was a specific statement that Mr. Kowalski was told by Maya regarding the provision of medicine, and it goes on. It's also a caregiver's failure to make a reasonable effort to protect the child from abuse, neglect, or exploitation by another person. And so in this instance, she was sheltered at Johns Hopkins All Children's Hospital, and Catherine Beatty was the perpetrator. But as we heard this morning, there was a disciplinary record. She had anger management issues. She was not removed. She was not taken off of Maya's case, and so this was allowed by the hospital. So the statements that may fall outside of abuse certainly fall within the neglect in the statute 827.03, and for that reason fall underneath 803.23.
Anything further?
the legislative intent could not possibly have envisioned the statute be construed so broadly that it's going to encompass a caregiver providing care to any medical malpractice action should it be construed this way. Any medical malpractice action involving a minor, it's merely because the plaintiff alleges a failure to provide medical care. That would not, the legislature could not possibly have envisioned this child neglect and abuse hearsay exception to encompass any time there's medical care or an alleged failure to give medical care in a hospital. I don't believe the legislator intended this that broadly.
Court, in Madam Court Reporter, you might want to mark this as the beginning of a ruling. I don't know if anyone's going to want it transcribed, but let's just mark it here. Before the court is the child victim hearsay motion filed by the plaintiff at DIN 2433. And in this particular motion, we are talking about various statements that Maya Kowalski made to Jack Kowalski in particular. The child victim hearsay statute obviously is 90.803 paren 23. And that statute in A1 and A2 established specific requirements to permit hearsay statements of a declarant child victim who is 16 years or younger to be admitted into evidence in a civil proceeding. The requirements of both of these subsections must be present because they are connected by the term and. Even if the both requirements are met, the child victim hearsay is not admissible unless the source of information or the method of circumstances by which the statement is reported indicates a lack of trustworthiness. I'll go ahead and go through this together, and I'm going to assume, for the sake of argument, that Maya Kowalski will be testifying at trial. That's been told to me that is going to happen. So under 23 paren A 2A, the child has to testify. And so I'm going to do my analysis, assuming that Maya will be testifying at trial. Section 90.80323A1 provides in relevant part that the court may consider the mental and physical age and maturity of the child, the nature and duration of the abuse or offense, the relationship of the child to the offender, the reliability of the assertion, and the reliability of the child victim, and any other factor deemed appropriate. And the seminal case, and that's not Seminole, it's the other spelling of Seminole, is State versus Townsend, 635 Southern 2nd, 942, pinpoint site 957 to 58. It's a 1994 case from the Florida Supreme Court, and it is widely viewed as kind of setting the procedure, the multiple step procedure that we have to follow. Here, the court conducted a hearing outside the presence of the jury and heard the testimony of Mr. Jack Kowalski. Now, I will pause and say, certainly we've already been through, I'm going to say half the trial at this point, approximately half of the trial. So generally these hearings happen prior to the start of trial, but we are at where we're at. I tend to agree that the statute 23 paren A, I've got to find some sort of qualifying, and I'm going to just use as a shorthand, child abuse or neglect, but the statute is much lengthier than that. Now, I don't think it necessarily is as narrowly tailored that it must be a criminal action, but I do think it has to be tied most likely to Section 827.03 and otherwise referenced in the pleading. When I say referenced, I mean falls to a count that is in our operative pleading. Here there are a number of statements that were made. Some of them were made on Friday, December 2nd by Maya to Jack Kowalski. Others are made at other times during Maya Kowalski's time at the Johns Hopkins. Let's deal with the easy one first, which are the statements that Maya made to Jack Kowalski. And even though Jack Kowalski did not have the precise date, whether it was January 7th, 2017, or sometime between January 7th and January 13th. These were made while Maya was still at Johns Hopkins All Children's Hospital, but at a time after her mom had died. So that leaves us with a 5 or 6 day window. These statements about that Maya relayed to Jack Kowalski about being photographed and that Maya did not want to be photographed, that if Maya didn't go along, she would not be able to go to court or go with Uncle, I think it was Scotty I wrote down, to go to court. And that Maya was scared if she challenged Miss Beatty, and if I didn't say it, that Maya told Miss Beatty not to photograph her. All of those statements clearly are within the pleadings. They certainly can be seen as an act of child abuse, and the circumstances behind those conversations between Jack Kowalski and Maya Kowalski are sufficiently trustworthy for the admission. The time, the content, the circumstances of those statements certainly are sufficient safeguards of the reliability. We also have the actual photographs of Johns Hopkins taken of Maya Kowalski, so we know as a matter of fact that Johns Hopkins All Children's Hospital did in fact photograph Maya Kowalski, and although not discussed during today's discussion on this, we had earlier in the trial in front of the jury Miss Kathy Beatty tell us that risk management at Johns Hopkins All Children's Hospital directed these photographs to be taken. So the court finds those statements have sufficient indicia of reliability and will permit Jack Kowalski to testify as to Maya Kowalski's hearsay statements. I probably need to say that at the time Maya Kowalski made those statements, Maya had just turned 11 years old. The court will also note, although this is from the totality of the circumstances of the trial to date, and I don't think anyone has contradicted this or is going to attempt to contradict this, but Maya Kowalski, given her long-term medical involvement, is more mature than a girl of her normal biological age. So her level of maturity is higher. The next set of statements are attributed to a Friday, December 2nd, 2016 conversation between Maya and her dad when dad was visiting with Maya at the hospital, and dad testified that these statements were made outside the presence of anyone else, which is consistent with the content of the types of concerns that Maya were relating. Those included Jack Kowalski testifying that Maya Kowalski said that the social worker, i.e. Kathy Beatty, was hugging and kissing her, being Maya, and making faces when Maya's mom was on the phone. The next one is that the social worker, Miss Beatty, told Maya that the mom is in a hospital getting medical treatment. The next statement is Dr. Elliott told Maya that her mom was putting Maya in a coma each week. The next statement is, and this was less clear from Mr. Kowalski, but his best recollection is that Maya said that Dr. Elliott said something about all of this was in Maya's head. There was also a statement about the use of the computer and Maya possibly using it without any sort of evidence to search on some sort of sex website. Now, the statements about using the computer to find a sex website or anything like that, even if it's true, is not a statement of abuse or neglect. So that statement is not going to qualify for something that Jack Kowalski can testify to. The statement attributed to Dr. Elliott about all this in Maya's head, because Jack Kowalski was not clear on his recollection of that comment, I do not find that there's enough reliability with that statement. So that statement cannot be testified to. The statement that Dr. Elliott told Maya that her mom was putting Maya in a coma each week, I am on the fence on that one. I'm in my mind, I can see that might be a child neglect issue, maybe. But I'm going to think about that one a little bit more. But Mr. Anderson, right now, my leaning is not to admit that statement, but I'm going to think about that one more. The other statements, the statements that the social worker was hugging and kissing Maya, you know, with the face, making the faces when Maya's mom was on the phone, and that Maya's mom is in the hospital getting medical treatment. Those statements that Maya Kowalski made to Jack Kowalski do qualify as either, or could qualify as abuse or neglect. The court would find that there are sufficient indications of reliability as to those statements to qualify for the child victim hearsay. So I will allow those statements that I specifically advised. Now, to be clear, that does not mean that those documents from which Mr. Kowalski used to refresh his recollection, that those documents are admissible. But Mr. Kowalski's testimony as to what Maya Kowalski told him as to those statements that I specifically said can be used under, or in your case in chief, under 90.803 paren 23. Any questions or clarifications
I just
as
sort
to
of-
my ruling, Mr. Altenberg?
A specific finding then that testimony is that Ms. Beatty was making faces about things when Beata was talking on, I guess, an iPad to her mother. And your finding is that Ms. Beatty's action of smirking or making some faces while listening to her mother in the room is an act of child abuse.
Or neglect, you know, that and because of the outrage count in this case, I mean, that's to an 11-year-old girl when the mom is having very limited contact, and it's supervised, that the supervisor is either making fun or making faces, that when we go back to 827.03, you know, talking about mental injury and talking about the mental health of a person and providing supervision under neglect of child, I think it is sufficient to fall under it. I mean, obviously, it's not a battery. I mean, clearly, I'm not saying it's a battery, but I do think that the language in 823, that the language in 823 as well as 90.803 paren 23 paren A is broad enough to include that conduct. Any other clarifications that the court needs to make?
The only thing the plaintiff would ask, Your Honor, is that, and we understand as to the Dr. Elliott said everything was in Maya's head. As to the computer, the sex website, introduction of the idea, the concept of porn sites to a 10-year-old, we only ask this, that the court, in light of his rulings on the other matters, at least while you're considering the Dr. Elliott said putting Maya in a coma, that you at least consider reconsidering on the porn site introduction, because in our view, that is certainly not towards the mental health of a 10-year-old who has not reached puberty and has no idea really about such things. And there's no indications here that although Maya is very smart and mature, that in any way, shape, or form, first she's reached puberty or approaching puberty at that point, nor is there any indication that she was sexually aware. So putting those things together, we asked the court to reconsider the computer website.
I'm not. And, as I said, Maya has a much greater maturity than at the time on Friday, December 2nd. Technically, she was 10 because her birthday was like a week later. She's talking to her dad about sex websites. Maya knew what the concept was. And so I'm not going to reconsider it. My notes, I missed one in my notes, and I apologize. The statement made to Jack Kowalski by Maya Kowalski that Kathy Beatty wanted to adopt Maya, I do find is a statement that would qualify under the statute, that there's sufficient indication of reliability and will be allowed for Jack Kowalski to testify to. I forgot, and I apologize for not saying that one, so I will say it. But I'm unsure on the Dr. Elliott. I'm going to spend more time, but I don't think it's going to come in. But I'm going to reserve on that one and that one only. So anything else before we move on to our next issue?
One question, clarification, Aaron. The I'll adopt you statement was made in the context of
Which statement?
Kathy Beatty's statement that I will adopt you or something to that effect.
Right, which I just said is coming in.
I understand.
So you want to keep talking about it?
Well, I only want to talk about it in the context of the visit to the chapel because I didn't hear a finding specifically as to whether, I know hugging and kissing was
Her
said.
dad didn't say anything about a chapel.
I understood. All right. Understood.
I know there was discussion about a chapel this morning in Kathy Beatty's testimony, but Jack Kowalski didn't say anything about chapel.
Okay.
Okay. Anything else on this issue? If not, why don't we take a 5-minute break? We're going to end my ruling on that, and we'll move on to exhibits when we come back in. 5 minutes. So we're now to exhibits, is that correct?
Yes, sir.
Okay. Well, let's start.
At the top, the first exhibit is 2123-610.
That's what I'm about. These ones we just went over.
Let's get it up. So what am I looking at?
You're looking at, below is what we're interested in, Your Honor.
Okay, so you're looking at the Kathy Beatty email and not the Lindsay Masika?
I expect there's a hearsay objection on that portion, but with Kathy Beatty, this is a party admission. This is a statement of Ms. Beatty and relevant to the lawsuit here.
Next page, please. So, what are the issues?
The simple issue to discuss is Ms. Beatty has been dropped, so she's no longer a party, where this would be admissible as a party opponent. The broader issue, again, I know we're sounding a little bit like a broken record, but this is starting to relitigate what happened at the dependency court. And the problem with admitting this email is the only way to start refuting the hearsay in this is to talk about, well, what happened next. Well, after November 29th, this information went to different lawyers, and then they went to a dependency court, and then four lawyers for the Kowalskis made their point about what visitation should be. Lawyers for DCF, including Mr. Silverstein, made recommendations about what visitation should be, and all of that culminated in people other than Johns Hopkins All Children's Hospital, who was not a party to the dependency, with the court crafting orders. And, you know, our general fear about getting into this testimony, which is probably somewhat out of the barn, unfortunately, but this is going to crack the barn wide open, is it's out of context. And the only way to talk about these is to talk about the next 100 actions that resulted after this email, all the arguments that were made to the dependency court, who made those arguments, what orders resulted. I'm sure we're going to have a discussion about what can the jury see in terms of some parts of the redacted orders, but this is getting really deep into how the sausage is made and is going to create issues for this court that I believe, you know, could result in a mistrial if we're starting to talk about what happened with dependency. That is our objection.
Do you need a response, Your Honor?
Yes. Yes, please.
Yes, Your Honor. With respect to party admission, was made at the time by the party.
Well, it's clearly a party admission. I'm not.
Thank you.
It's whether
All right.
the other side of Mr. Shapiro's argument is what I'm focusing on.
Thank you. Well, the defense has requested an instruction, and I think the court's going to give one on the scope of the court orders. And we have been consistent that what was happening here is the hospital was feeding misinformation to DCF in an effort to get court orders to tighten the vice grip on the Kowalskis. And so this is a perfect example. The lead social worker in the case is characterizing the phone conversation that she listens in on without authority and characterizing that phone call as being damaging to the child, and then suggesting to DCF that for the reason of Beata allegedly acting improperly during that phone call, that DCF then should then push for additional restrictions on Beata Kowalski's limited already visitation with her daughter. And that's exactly what happens. So we need to be able to point out, since the court orders are coming in, the jury's been very curious about these court orders. What was the genesis of these court orders? Was it really just the hospital implementing orders and DCF instructions, or as we've pointed out, was it the hospital taking advantage of the situation and leveraging their information from listening in on phone calls to push DCF in that direction?
And it's not addressed to any attorney. This is strictly communication between DCF, and the court has previously ruled that these DCF memos do not have the force of law. So it seems like they want all the good parts about the orders, and they don't want to get involved at all in how they manufactured some of them. And let me say one other thing. If the court hears the actual phone call that this is referencing, which we want to put into evidence,
I think I've actually already listened to that one.
all right, then the court can compare for himself exactly the difference between what was represented and what was on that call.
Ms. Crowells was standing up earlier.
Yes, I know, but I'm deferring.
Please, the court. I think Mr. Whitney just kind of gave away the game. Game that plaintiffs are playing here is to relitigate in detail the dependency action. Theory that Mr. Whitney just elucidated is that there were statements being made to DCF or the dependency court that were incorrect for whatever reason they believe, and that forms the sole basis for the court's ruling, and that if those things weren't done, then there would not have been this ruling. They are relitigating exactly what the theory is in the DCF and the dependency action. We've taken the position from day one in this case that there is an immunity that derives from any act or omission that is permitted or required by Chapter 39, and there is an immunity for any act or omission that is connected with the judicial proceeding that was the dependency action. If there was a problem in the dependency action, the remedy was for one of the 4 lawyers, arguably 5, counting the gal lawyer, one of the 5 lawyers representing this family, to take it up with Judge Hayworth at that time and to deal with it at that time. What's going on right now is that we are going into detail on orders, detail on the execution of those orders or the interpretation of those orders, detail on what was being told to DCF, and everything connected with the DCF proceeding as well as the dependency action. This is going to the heart of relitigating that very case that you've been saying that we thought we understood was being avoided, and yet here we are, and it's going. And this will open floodgates that have already been opened by the rulings on what was permitted from Ms. Beatty's deposition. There is more than confusion being created regarding what DCF is responsible for versus what the hospital is responsible for. We can't defend what we did without going deeply into all of the orders and all of the machinations of DCF. The fact of the matter is that the court in the dependency proceeding heard from multiple lawyers and multiple witnesses, not just all children's, and made a decision that in the final analysis was at variance with what was recommended by the hospital. So, Judge, I just want to make clear that in continuing to permit exploration of what was told to DCF, what was told to the dependency court, what was recommended to the dependency court, what the orders consisted of, what happened in the dependency court, and continuing to do that, we are invading an immunity that should be respected and we should never have crossed to begin with.
Let me ask this. As of November 29th, what was the status of the court order with respect to communication and telephone calls? Can someone give me that order?
As of November 29th,
farther down.
It's the order, I believe, dated November 10th. I don't think it had been changed
November
since
10th?
then.
Okay.
And it says,
Can someone hand me a copy of it,
We have an exhibit number if you find it.
give me the dependency case number and give me a DIN number, I can pull it that way as well.
Order on shelter
I'm
review.
not sure I can give you a DIN number, that I had given you a proposed standard instruction that had the ordered and adjudged part of all of those.
What is the dependency number? Does someone have that case number?
Yes, the dependency number is case number 2016-DP-601-NC.
And you said, Mr. Altenburn, that this was, the most recent was it was November 10th?
10th.
The relevant paragraph, Your Honor, I believe is paragraph B at the top of page 3.
Okay, well, that order looks like it was,
There's a note that date. That's.
yeah, I'm trying to find it.
I have a copy if Your Honor would like to see it in hard copy. Do we have an extra copy? Or I can put it on the Elmo.
Okay, so the dependency court signed it on the 10th, but it was docketed on the 14th. Okay, let me read it. And you said it's on the
Yes,
third
that's
page?
correct. That's correct, Jeff.
You said it's on the third page?
Page
Yeah.
6th page.
Oh, well, we have a different number of 10th order. Ours says contact between Mrs. Kowalski and Maya on the third page.
Is that in the body, or
Is that
is that in the order? The ordered and adjudged part is what I'm.
I think Mr. Shapiro agrees with me.
Yeah, I see it.
What does it say on page 3? Because I don't have that.
Let me ask a dumb question. When the dependency court said telephone communication between the mother and Maya is authorized, but only when supervised by the guardian ad litem or the case manager at times convenient to them in the facility, why is Kathy Beatty monitoring the call?
That's not a dumb question, and my recollection of the DCF hearing, we can go back on that at some point in time, because the guardian ad litem and the case manager couldn't find time to do these, it was okay for her to listen rather than one of the other two, is my recollection.
We had a different recollection.
Okay.
And she testified to it this morning. She decided that the best way to communicate with the mother between Maya and Beata was for Kathy Beatty to use her personal cell phone and walk into Maya Kowalski's room and set the cell phone on speakerphone on the bed or near Maya and remain in the room during those conversations. That was her decision.
Yeah.
And during those calls, there was the authorized supervisor from, what is it? Does it say in the order DCF or the guardian ad litem?
Judge,
And
Okay, but Ms. Beatty also testified that DCF asked Ms. Beatty to basically perform their function.
yes, that's correct, Judge, especially, and she would come in on the weekends too and do that as well, because they were not available and wouldn't get the calls connected.
show us that particular email or memo.
Respectfully, Judge, in addition to that, if there was a problem with it, the remedy was to go back to the dependency court.
Right.
Just as if there's a problem with something that goes on before Your Honor in this court, our remedy is to come to you in this proceeding, not to file a collateral action seeking damages.
Yeah, well, explain then how we are supposed to know about this.
Time out. I'm reading this email from Kathy Beatty to all the people that are effectively the DCF folks. And it is a recommendation to DCF as to how the order should be changed. This doesn't, and frankly, that's how it should be done. It's like, if they don't like something, this is, go to the folks who are gonna go to the court, and this is what the hospital is gonna recommend. I see that this is part of the dependency process. And so, my inclination is this is not something that would be admissible in this proceeding.
The problem is that we, in the dependency action, nobody knew about this. This was not copied to anyone. It wasn't copied to the other lawyers. This was not a proceeding where you had the court's approval, sanction, or anything else, because it was unilaterally and not only that, but I think that My Florida Families is a contractor of DCF. Nonetheless, the problem is no one knew anything about this, and this was not submitted to the court. No one knew that Ms. Beatty was the only person at Johns Hopkins who was sending this in. This is from a social worker. This is not from a manager or anyone else at Johns Hopkins. This is from a social worker who purportedly, according to them, has no managerial responsibility or anything close to it. So why are we having a social worker write to a third-party contractor, not copy anyone from the lawyers for the Kowalskis at that time, trying to manipulate it, which then results in the next order, which I think is the 1227, which includes no disparaging comments shall be made by any visitor. The problem here is that this was not part of the regular system. This was not part of what the court envisioned. This was a social worker without authority writing to a third-party contractor, influencing the system. And this is not something that would have ever been shown to the court, and it would not have been shown in the proceedings. It would only go to this contractor, who presumably would then influence the DCF attorney, Silverstein, who we plan to call. And then from there, Silverstein would decide what to do. So the actual decisions, yes, down the road. But the point and the relevance of it is the hospital is allowing Beatty to influence the court proceedings unbeknownst, and keep one other thing in mind, we want to emphasize in this. The hospital was not a party. The hospital was not supposed to be dictating or influencing court action, other than if there was a direct violation of the court order or a specific rule that the hospital handed down. And our case is this. The patient's rights set forth the rights that the Kowalskis relied on and had the right to rely on through this. Yet the hospital, and not even the hospital, I don't think, basically Ms. Beatty was coming up with bizarre rules, strange inferences, and conduct that was totally out of line, and was trying to influence the proceedings as though the hospital was a party. And if you look closely at some of those transcripts, Judge, I think what you're going to find is that the hospital, far from being just a participant, which under Chapter 39, they're not supposed to be influencing the proceedings. They are not supposed to be advocating one way or the other. They're simply supposed to be observers. And yet, there was a lot of advocacy and a lot of trying to get this done. And so our point is, there's got to be a cutoff. At some point, the court will have to rule, but there needs to be a cutoff below
Let's
that.
talk about cutoffs for a second.
Yes, sir.
I've been given a 7 or 8 page list. We're still on number 1, and we're 30 minutes into this. I hear what you're saying. Let me tell you my thoughts right this second. This email goes to the question of whether the dependency court should or should not change the contact. That is an issue within the dependency court. I don't see why the request to change the rules is something that we need to address in this case. Now, having said that, in my mind, and Mr. Altenberg, you might want to raise your antennas on this because I think it's going to impact you the most. I can see an instruction by me saying, as of whatever date, November 10th or 14th or whatever date this was, the contact by Mrs. Kowalski was allowed to be supervised by the guardian ad litem or the case manager at a time convenient to them in the facilities. I can then see an interrogatory question that says, did DCF delegate its role under this order to Miss Beatty or the hospital? Yes or no? If the answer is yes, then there would have to be an instruction that, you got to disregard the concerns about the contact starting on November 10th to whenever that court order ended. If the answer of that is no, then the hospital had no authority to monitor that call and then could be part of the...
So we're going to have to put on testimony, put in all the transcripts of these hearings and read
No.
the hearings where this is discussed?
No. The issue, I think the issue is whether DCF authorized Kathy Beatty to operate under this court order in DCF's stead, from a matter of fact. And if the jury says yes, then what Miss Beatty was doing was under the authority of the court order. If the jury says no, then I don't see a court order that would have allowed Miss Beatty to listen in on the call.
So I guess I call Mr. Zimmer, the lawyer, Mr. Silverstein, and the people from DCF to explain this whole process to me.
No, just whether as of this date that they had authorized, because I can see the court instructing the jury to the extent on as of November 10th. I keep on saying November 14th because that's the day it was docketed. Right. And you know what I'm talking about there.
Yes.
But as of that date, the dependency court stated that the communication between the mother and Maya was to be supervised by the guardian ad litem or the case manager at a time was convenient to them and the facility. There's nothing here that says that the facility can listen in. Now, if Miss Beatty was delegated the authority of DCF, if you will, to operate under DCF's position or the case manager's position under this court order, if that's a issue of fact and the jury says yes, then it would seem to me that all of this discussion about listening in on conversations, we have to tell the jury to disregard.
And this is relevant to which they're intentional infliction. I'm not sure what it's relevant to.
Well, to me, that's kind of part of an outrage, listening in on someone's telephone conversations without authority.
Well, first of all, Mrs. Kowalski knew it was going on because this was the conversation where 3 or 4 times there was an interruption to say, no, you got to redirect, you can't go there. And so she knows that the woman is on the phone with her.
Well, it's not whether she knows, is whether Miss Beatty had any authority to be on that telephone call.
Judge, respectfully, if that's the case, and Ms. Kowalski's aware that someone is monitoring the telephone conversation outside the parameters of the court's visitation order, then the remedy at that time is her lawyer takes the matter back to the court, as indeed they did several days later in a day-long hearing before Judge Hayworth on the terms of the visitation.
Mr. Hunter, on this November 10th or November 14th order, can you show me any paragraph that authorized the hospital to listen in on the telephone call? Can you point to me?
I can't. All I'm saying to you, Judge, is if the complaint is, let's assume for the sake of discussion that Ms. Beatty's testimony is to the effect, as it was this morning, that the Guardian and MyFlorida.com, that is DCF, by the way.
I know.
That they were unable, unwilling, or not staffed to provide that. And so she did as she said she did and supplied herself to do it. Now, if you assume for the sake of discussion that's correct, and that she stepped outside the parameters of what she was supposed to do, then the remedy for that, her acting outside the court's visitation order, is to go back to the dependency court. And what I'm suggesting to Your Honor is that's exactly what happened, because if you look in the dependency action, about 10 days later, I wonder about what, December 5th, 6th, there was a day-long hearing with everybody, with all parties, mom, dad, the child, the gal, everybody represented by counsel, where they went over exactly what the visitation terms are. What I'm suggesting to Your Honor is that you can't get into this, and you're correct to some extent on this, but what I'm suggesting to you is that the entire issue of this is part and parcel of the dependency court's jurisdiction in that proceeding, and if you start going into it, we're relitigating it.
I fundamentally disagree. I see the question differently. As I said, when I look at this email, I see this as a request ultimately to the dependency court to alter the court order on visitation. And to me, that is an appropriate action within the dependency court proceeding to change the court order. But as of November 10th, the dependency court had issued an order that, in my mind, when I'm looking at it, does not authorize the hospital to listen in on the conversation. Now, I'm either being put in the position where I have to make a factual finding, which I don't think I'm allowed to do since we have a jury here. So to me, it's a question of fact as to whether or not DCF had delegated its authority under the November 10th order to allow Ms. Beatty to supervise those conversations instead of the case manager. If the jury finds the answer to that is yes, then we'll have to have an instruction to the effect of, then members of the jury, you cannot consider anything having to do with the supervising the telephone calls as any type of conduct that would have a finding of outrage or damages. But if the answer to that is no, then I think it's fair game. And so I think the evidence for that is whether or not DCF authorized Miss Beatty. That sounds like a pretty limited scope of testimony as opposed to what happened later on in front of Judge Harris. Because that I don't want to get into, and I don't think you need to get into that. I think you just need to get into, as of December 10th, or sorry, on November 10th, this is what the court order said, and it clearly doesn't give the hospital the right that you think it does, and it's a question of fact as to whether there was a delegation.
Judge, what I'm suggesting to you is that is not the only issue like this that the court's going to be confronted with.
Well, this is issue number 1 on this sheet that we're now 40 minutes into, and I don't think I'm changing my mind on this right this second.
I would urge Your Honor to consider it, that's all.
Judge, can I,
Folks, if we are ever going to get to number 3 on this list, not to mention number 400 on this list, we have got to do this faster.
I understand, Judge. But is the court reserving ruling on this? Because I think the court needs to hear from DCF or somebody on that issue before it allows this in, because if all the testimony is she had the authority, then this email should not come in.
I already said that, to me, this email should not come in.
Okay, sorry.
I said that 20 minutes ago.
Yes, you did, sir. I'm sorry.
But I wanted to be clear because I've seen this issue now as to where I thought this whole thing's going to go. And I was alerting Mr. Altenburn to the possible jury instruction that I'm envisioning is going to have to be given.
Okay.
I understood, Your Honor. I'm trying to alert you to where I think it's going to go, and this is the first step in a long path.
Well, maybe we can agree to disagree at this point.
Currently, the email is not coming into evidence.
We're the ones
Oh,
that have.
time out. Only one at a time. It's Mr. Altenburn's turn.
The email currently is not coming into evidence. Is that right?
Correct.
Okay.
But I'm telling you that the issue of authority, because I know I've already talked to you about wanting to do an instruction that talks about the visitation and the dates and the times, and I can see that being a specific issue that the jury is going to have to make a factual finding on. What's next?
2270, Your Honor.
Okay, well, there was like 3 or 4
Yeah, we're
others.
skipping a couple, given
Time constraints.
Okay, so 2270. And this is from Kathy Beatty to Dr. Amin.
Yes, Your Honor. There's a second page.
Let me see number 2, please. Who is this to?
To Dr. Well, it's only addressed to Dipti Amin.
No, but this letter, which is 2270-002.
It doesn't say.
Judge, they know that ultimately this turns into a letter from Dr. Amin in the dependency court action, isn't it?
This is an internal email from Kathy Beatty to Dr. Amin.
He's avoiding the question.
Okay. Can Mr. Reyes, can you make 002 a little bit larger for me, please? Mr. Whitney, this goes to the same issue that we were just talking about, that this letter, because it sounds like this was ultimately delivered to the dependency court to advocate for a change of visitation in the dependency court. To me, that is off limits and not what this trial is about. The fact that someone made a suggestion to make visitation more rigorous or less rigorous is not an issue in this case. It's ultimately when the dependency court ruled what was followed or not followed.
Understood. I think there's a way to deal with this letter through specific redactions taking out mention of recommendations to DCF and then ultimately the court. For example, what you see here, don't stay there. The top paragraph that's displayed right now, for example. This has to do with Catherine Beatty's statements about how Maya's doing in the hospital, which is absolutely relevant to the case and goes to her credibility, Maya's credibility, and what was going on.
I will tell you, yes, if everything about recommendations to the dependency court, recommendations to DCF and supervision and all of that is excised, and all you have is the observation and statements about Maya, I would consider that.
We will put those redactions to them.
Yeah, we'll have to see the redaction, Judge, and then we'll have argument.
Yeah, I mean, but if it's an agent of Johns Hopkins Children's Hospital making an observation about how Maya Kowalski was physically doing an observation, that's probably going to be relevant and admissible. But nothing about making a recommendation to the dependency court for changing a visitation. That's not coming in any exhibit that you got.
In the interest of time, we'd like to advance a couple of pages. I think it's the third page, although my page is not numbered. And get to the audio clips, which begin at 2608A, 2608 alpha.
And before we start playing these audio clips, are all of these clips, have we cleared any sort of potential criminal problems with these clips?
These are calls between Maya Kowalski and Beata Kowalski, the first.
So in this case, Jack Kowalski as Maya's guardian could consent, and on the other side, Beata, who hit record, is obviously consenting. So
I'm just clarifying, there's no one else on the call?
No. Catherine Beatty, at times, will, in supervising the calls, interject herself into these calls.
it was Miss Beatty, was she aware?
She was. It's announced at the beginning of the call that by Beata Kowalski, I'm recording this call. And secondly, there has to be a reasonable expectation of privacy. And I know we just went over these letters, but she characterized the contents of these calls and reported the contents of these calls that she was on. So she has no reasonable expectation of privacy in these calls.
Not only that, but they're on a speakerphone in a hospital with people walking by. There's case law that says that in exact that circumstance where they're in a hospital, in a place where it's a speakerphone and anyone can listen in.
Well, before we get really down this path, I've heard conflicting things as to whether Miss Beatty was going to waive or not waive.
Not waiving.
Not waiving. Okay, so if Miss Beatty was on the call and it was announced that the call is being recorded and Miss Beatty did not object, then it would seem, without even having to hear it, that she's waived, she being Miss Beatty has waived any expectation of privacy, assuming there is any. But is that actually the case?
We'd have to listen to the beginning. I think the first clip includes that announcement, if not right before it. Do we know?
What's the date of the call, please?
This phone call is November 15th, 2016. And the first clip that we would like to play for the court is 1 minute and 13 seconds.
Well, let's hear if there's consent do you have the consent at the start of the call that we could hear before we?
As I stand here, I don't know if it's within this clip or just before it.
I just don't know, Judge. Sorry, there's too many clips. I don't recollect off the top of my head.
I would feel more comfortable if you could assure us that no one's going to jail by playing this clip.
So we'll play it to ourselves.
Play it privately.
Yes,
from my
please.
laptop.
Go ahead and listen to it.
You said this is 2605,
2608.
2608, A is an alpha.
Yes, Your Honor.
Flipping back to courtroom audio.
I've got it to his,
We're
so,
perfect. I was just letting you know that was the delay. I had to switch it back.
Oh, okay.
I was doing it privately. May I publish?
yes.
Okay, I'm recording this phone call so everybody knows.
Okay, hi, Mommy.
Hi, honey. How are you, sweetie pie?
I'm hurting. I miss you.
I miss you so much too. I miss you so much every day. Every single day.
You don't know how happy it makes me feel to hear your voice.
Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice too. Yeah.
I hope you.
What did you say, sweetie?
I hope I can see you soon.
I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay? Yeah.
Beata, we're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Is that the conclusion of the clip?
Yes, Your Honor.
Yes.
Okay. Are we, are B and C the same call?
Yes, they are, Your Honor.
Why don't we just, and I'm assuming that at no point in the interim, anyone has removed consent. Is that correct?
I've listened to it. No one removed consent on this call.
Thank you.
Thank you, Mr. Altenberg. Then you can play B as in Bravo.
How you doing? How is PT and OT going for you?
Not good.
Why is it?
Okay, Beata, we can't discuss any of those type of matters, okay?
Okay.
Is that the conclusion of Bravo?
Yes, Your Honor.
Let's listen to Charlie.
Charlie is 55 seconds.
And what do you usually need help with?
My pants.
What happens with the pants?
I just can't lift them up.
You can't pull up the pants anymore?
No.
When did that start, Maya?
Oh, I don't know. Maybe a while ago. I don't know. I don't remember when it started.
Okay.
TBH.
What's PBH?
Yeah, I'm going to redirect that line of conversation now, thank you.
Okay.
Does that finish it?
The end of that one.
Yes, Your Honor.
Okay, so that concludes that telephone call that you wanted to publish.
Yes, Your Honor.
Okay, go ahead and what is the argument, or let me hear the objection, I guess, is where we need to start.
Well, Your Honor, object hearsay, certainly as to all of Beata's comments. I don't know what the relevance is to what issue, and 9403. I mean, it's clearly just to appeal to the emotions of the jury. Those are the arguments. I mean, it's hearsay, it's 9403, and it's not relevant to the issues.
And Mr. Altenberg, going back to that last discussion we were having for 40 minutes.
Yes.
On the factual findings, there probably also needs to be a factual finding as to if the jury were to find that there was a delegation we need a date of the delegation, because
What is the date on that phone call?
this one's 11/15, which would have been the day after the order was docketed, which is why I just am in my mind thinking we probably need to find a date of if the jury were to find that there had been a delegation.
And thank you, Judge, that brings up another issue. If there's an issue with the manner in which Mrs. Beatty was handling this call, that's an issue for the dependency court. And they want to use this to try to say that Mrs. Beatty wasn't appropriately monitoring the calls as directed by the dependency court.
But again, if Miss Beatty had not been authorized by DCF, and clearly the dependency court did not authorize the hospital to monitor the call, then under what authority was she acting on November 15th?
The call
Well,
would not-
that's, go
The
ahead.
call would not have taken place at all because there wasn't somebody from DCF or guardian on that phone calls, is my knowledge.
Clearly she's assisting in placing the call, Judge, but I heard Your Honor. So I would suggest that there needs to defer on the admission of this until that testimony is heard, because you can't put that cat back in the barn.
But here's the conundrum I'm in. At some point, someone has to make the factual determination on the delegation and when.
But if there's
And
no,
there's no summary judgment that was addressed to this issue.
but
And so how am I supposed to take an issue from the jury?
if there's no dispute as to the fact, if there's nobody that's going to testify otherwise, if DCF comes in and says, yes, we asked her to do it, if the attorney for DCF comes in and says, yes, we asked her to do it, and there's no factual dispute, then absolutely the court can make that determination.
Can the jury disregard the testimony of Ms. Beatty and potentially of DCF?
If there's nobody that testifies in contradiction, how could they ignore that, Judge? There's not going to be, if there's no contrary testimony, if DCF says we gave her the authority, we asked her to do it, if the attorney says we asked her to do it, and there's no contrary evidence, there's no factual determination for the jury to define. That's all the facts. That's all there is. That's a directed verdict.
No, not at all. This is summary judgment you're arguing summary judgment standard in open court.
Well, summary judgment is now married to directed verdict. Right.
Yeah.
I understand, Judge. However, the jury does have the right to reject that testimony if they so deem. And if they find that Mr. Silverstein at that point either did not have enough information or that he did not have the authority, if the court finds he did not have the authority. And so there are a number of hoops to jump through here.
So now they're going to argue, Judge, and try to prove it to this court and this jury that the DCF didn't have authority. That's a DCF hearing.
No.
I go back to the dependency court order. It says telephone communication between the mother and Maya is authorized, but only when supervised by the guardian ad litem. And obviously, it doesn't seem like that's an issue here. Or the case manager at times convenient to them in the facility. So
There's nothing in the complaint, to the best of my knowledge, it's 105 pages, saying that she was listening in on conversations in violation of the court order. This is all quite a surprise to me, frankly.
Well, the argument just came up by the defense on this. We were arguing outrageous conduct and limiting access to Maya.
yeah, I am comfortable that this issue is contained within the pleadings. It's what I'm hearing Ms. Crowell say is if the defense only presents evidence of DCF authorized or the case manager authorized Kathy Beatty and there is no contrary evidence, then why put this information in?
Yes, Judge, because then you're putting something in that needs a limiting instruction, as opposed to they have to first, I would think, establish the basis that allows it in. So I would think before this comes in, they would have to establish that anyway, that's my argument. That you would allow them to put in evidence that then has the fifth limiting instruction for this jury, as opposed to waiting.
Anything else, Mr. Anderson?
Yes, I had a brilliant point, and now it just escaped me. However,
They call that a senior moment.
it strikes me that the issue is not going to be presented in the plaintiff's case. So it would have to be at the conclusion of the defense's case, and at that point, if the court decided that it was a DV, then the court would have to, in the instruction, say, as to evidence regarding this, this, and this, the court instructs you to disregard that, which happens in almost every trial. Not every trial, it's not like a slip and fall, but in every big complex trial, there are instructions about what evidence you can consider and what evidence you can't. So it can be corrected at the end.
I tend to agree with Mr. Anderson on this. I hear what the defense is saying, and ultimately you might get a DV on this, but maybe not. I don't know. But I think the question that the jury has to answer is whether or not they were authorized, that the hospital through Miss Beatty was authorized.
If the court
Because
is
the
inclined,
court order doesn't say anything about the hospital.
if the court is inclined to let it in, then why is all the preamble coming in up to the point where Miss Beatty interrupts the call?
Because there's other exceptions for those statements.
What's the, I mean, if the point of this is to show Miss Beatty interrupting the call, then it should just be the parts of Miss Beatty's interrupting as opposed to the rest of the call.
Well, when Maya's talking to mom about not being able to pull up the pants, that seems to be something that really the hospital should have been told about for medical purposes.
Well, what about the mom's response, Judge? That's hearsay. The conversation
questions.
between the mom and the daughter, maybe Maya's comment can come in as I can't pull my pants up, but then you have Beata's comments back. What's the hearsay exception for that? It's a
And
conversation.
What is mom's comments being used for the truth of the matter asserted?
Exactly.
I'm pretty comfortable with 2608 A, B, and C coming in. Now, Mr. Anderson, at the end of this trial, if there's a DV and I grant the DV,
There'll be a mean instruction.
there's going to be a very strong instruction about what they're going to have to ignore.
I understand.
Okay?
Your Honor, just so it's clear in the record to you that while the part about the phone calls with Mrs. Kowalski being supervised, in the previous one that says that the communications with Maya, Mr. Kowalski, and Kyle, which were more open, are not to discuss her pain or its causes and shall be positive as to her rehabilitation efforts and progress, and will also follow the recommendations of faculty staff as to how to interact with her. So what's going on in this phone call was what was ordered for everybody else in the family, and that's discussed with some length in the DCF hearings. So the one that's coming in with her interrupting things that none of the other family can do with her, I don't understand why that's coming in.
I'm going with what the dependency court order says, not what was talked about in the dependency hearing, unless that is the actual court order that we've got to address.
This is a paragraph in that same order. So unless she's exempt because she can have the supervised calls, Mr. Kowalski was actually promising he could work with her to get her to obey this stuff at some point.
I guess I'm not following, because paragraph A says contact between Maya, Mr. Kowalski, and Kyle Kowalski.
That's correct.
And it doesn't say anything about Beata Kowalski there.
You're right. It does, the other one doesn't say I incorporate this by reference. So she could just talk about any old thing she wanted to. So is your position?
Well, perhaps when you and Mr. Elliott present to be the jury instruction about the dependency court orders, we can have that discussion.
As
But
Mr. Zimmerman explained yesterday, these things were complicated and she had to interpret these things as just read them because these are not plain and unambiguous orders. So,
I hear what you're saying,
okay.
and I'm I'm trying to make it all make sense for everybody. So 2608 Alpha Bravo and Charlie can come in. What's next?
2627A. This is a audio recording made at the time of ketamine infusions at Dr. Kirkpatrick's office.
And did everyone give consent?
Dr. Kirkpatrick has consented.
Is there anyone else besides
What's the date?
Maya, Mom, and Dr. Kirkpatrick?
I need to listen to the 15th. I don't believe so, but let me just verify one more time.
What's the date? Yes, I'm sorry.
October 8th, 2015. No, no. It's just Ms. Kowalski and Maya.
Okay. Then let's play 2627A as an alpha.
Another kiss. Kiss, 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 kiss. I love you. I love you to the moon and back. Love you. I love you to the moon and back.
What is this one for?
Moaning in the background, you can hear the child in pain.
I don't think so.
And
No.
it was going to be used with Dr. Kirkpatrick as well to explain a few things about the testing at that point and the pain Maya was in. Excuse me, the discomfort she was in at the time.
I don't think this clip
Okay,
is,
move on
is
to the next one then.
good for that issue at all. So I'm going to deny.
Wait, what was the number of that again, please?
2627A as an alpha. So what's the next clip, Mr. Whitney?
2631 Alpha. And
This is a different date.
this is now October 12th, 2015. We have, it's like 6 clips chosen from this recording.
And again, do we have a consent issue, or is all consent issues
The only
resolved?
participants in this would be Dr. Kirkpatrick, Maya, Beata, and Jack may make an appearance in 1 or 2 of them.
This is from Kirkpatrick's file?
Yes.
Let's play 2631A as an alpha.
Here we go. Okay, so, anyway, so you can see that, her short-term memory is pretty botched, and that's good. That's a good thing. We want that. That's what we want to do. So we can say she got an adequate dose. So the max we could ever do on her is probably 135. I mean, that's for her size and everything, that's pretty good, type thing. So, but we wanted to have that as a record, so we're going to put down here, no. This is just moving around because she's in this weird thing. She's probably in God knows where you're at. I mean, you could be on planet, well, I can't say planet Pluto anymore because it's not a planet anymore. They call it it's a satellite out there. But anyway, you're far out. Yeah. So you're thrashing around and all that kind of stuff. And the thing is, you probably don't remember much of that at all, right? Okay. And that's normal. That's perfectly normal. But the thing about it is, it's one of these things where you're just trying to balance things out, not giving enough, but not going crazy and going overboard. Okay. Because we were concerned she got a hyperactive airway. If she gets stressed too much, we could activate that end of things, which we don't want to do. So I think we managed to balance this thing out in a fairly good manner. We didn't have to give her, and there were times when I didn't even give her any Versed. Okay, remember?
Yeah,
Last
on the
time.
third day,
Yeah.
she didn't get any Versed till the very end.
Yeah, right. And she seemed to handle that pretty good.
Yeah, the last day, I'm sorry, not the
Last
third
day.
day, the
Yeah.
last
Third day.
day.
Right, right,
Yeah.
couple.
Right,
The
right.
first 2 days were
Right.
hell,
Right.
but the third day
Right.
was better. The
And
fourth
sometimes
day,
what you do, you just try something like that and just see how she does. You know, if she does fine, then the less versa we give, the more ketamine can do its job. Okay, all right. So no, I'm going to put down, but I want you to understand why I'm putting no adverse hallucinations where she's yelling and screaming, trying to run out the door.
Right.
yeah, the first 2 days she wanted to get out of there.
Yeah, right.
She was
No, I
seeing
was just
monsters.
scared. I
Yes,
was
you.
just
She
scared.
saw monsters the first 2 days. Those 2 days were really hard.
But
Trying
then
to
it got
calm.
better.
Okay, Maya, I'm talking. So it was hard to keep her calm. But then on the third day, it got a little bit better. She had pleasant hallucinations. You know.
She was
Yeah,
dreaming of
Yeah, she
heaven.
was dreaming, talking to God. It was pleasant. And then on the last day, she was laughing.
Yeah.
She was high. Floating high.
She was having a party.
Yes.
And she didn't have no nausea, vomiting.
No, she had one after the first treatment.
What are we using this for, plaintiff?
Statements for medical purpose, then existing mental, emotional, physical condition.
Of the doctor?
Well, clearly it's not being used to prove whether Pluto is a planet or not.
Judge, it's clearly a hearsay. I mean, it's the doctor going on and on and on and on and on. It's no exception applies to that.
I'm going to give you another opportunity, plaintiffs, if you could, because I'm about ready to or to agree with the
We're
defense.
not going to argue strongly on that one. It's fine.
Okay, well, I'm going to deny the admission of A as an alpha. Now, is Bravo, Charlie, Delta, Echo, and Foxtrot all kind of the same?
There are there's less verbiage by Dr. Kirkpatrick and the others. However, again, we're approaching the end of the day, so we'd like to advance again on the list to the videos that we have listed here towards the end of the list. And the first one is 2686. It's only 3 seconds.
What day is this from?
January 8th, 2016.
Isn't this about the same time as her and her brother in the pool?
That's a little later.
That was in August of 2016, Your Honor. This is shortly after she returned from Mexico.
Don't blink or you'll miss it.
Just a moment.
Sure.
Thank you.
Cute girls. Really cute. Got it.
Can I
Judges,
see it again, please?
Cute girls. Really cute. Got it.
cumulative, Judge. I think there's several photographs similar to that.
We don't have a video or a clip from this time frame, which is clearly relevant because they want to attack the treatments in Mexico and argue that they had detrimental effect to Maya Kowalski. So the other video, as I just mentioned, was from August, and this is shortly after she returned.
The important thing is the legs, Judge.
I saw it and show some dystonia too.
It's cumulative.
Yeah, I'm going to deny the cumulative. I will allow 2648, A as an alpha. What's next?
What was the number on that, Judge?
2648, A as an alpha?
I thought it was 2686.
Yeah.
I apologize, Madam Clerk, I was wrong. It's 2686. Thank you all for keeping me straight. Apologize about that.
The
What's
next
next?
one is 26900.
And this is April 24th, 2016, and it's it's just under a minute long.
It depicts Maya secretly recording Beata swimming, and the only thing she says is, "I love you." And it's
Gunfire? That was a loud one.
Uh-huh. If you're watching this, Mommy, I want you to know that I love you. Send you kisses. You'll know it's from me.
I'm sorry, Judge, that was, who in the pool?
That was Beata Kowalski swimming and Maya Kowalski videotaping and then narrating and making the statements.
Objection.
8031, spontaneous statement describing or explaining an event or condition made while perceiving it or immediately thereafter, or excited utterance, or then existing mental, emotional, or physical condition.
Doesn't meet any of those.
Business record? No.
That would almost be
Mine's
funny if
business
it was
record.
1 o'clock.
It'd be hilarious at 11:15.
Judge, it does, I would think it does fit then, the then existing mental, emotional, physical condition, because it definitely shows what her state of mind was as to her mother. The reason we want this in is that you've got Dr. Lewis's report in which he's saying that through this period of time that there was an antagonistic relationship between Beata and Maya. This video, as short as it is, demonstrates Maya's state of mind as to her mother during the period that Lewis says it's supposed to be a antagonistic one.
Good try, but no.
One more try. 801-2 says a statement is not hearsay if declarant testifies at trial. Maya's the declarant. And the testimony, and then the statement is consistent with declarant's testimony and offered to rebut charge of improper influence, motive, or recent fabrication. The entire allegation of Munchausen by proxy is that Beata had an improper influence on Maya Kowalski.
So the relationship between the two should be admissible.
Good try, no.
Okay.
What's next?
Then this will be 2691. This is a short video, only 46 seconds of Maya in scuba practice in the pool, April 30th, 2016, being led around by her father.
Objection, Your Honor, cumulative.
What is the objection?
I'm going to overrule that. This shows Maya's abilities in April. You know, there was the video we just let in January. There's the videos in August, and there's been testimony about the progression of her improvement in that time. So I'm going to allow 2691 into evidence. Next one.
We'd like to show then skip to, in the interest of time, 2695. It's a video of Maya with her walker at home on the ground and then her upper body strength. So July 28th.
Before we
2016.
play this one, what did I do with the one where she's dancing in the bed? Didn't I let that in?
They withdrew that.
Oh, they withdrew it. Okay. Okay.
We have another one, but we'll get to it.
They withdrew it at that time. I'm not saying they withdrew it.
Video of Maya playing on Walker at home, July 28th, 2016. It's 2695.
2695. Let's play it.
28 seconds.
That's better. I love you. Now go down slowly. Go down slowly. Good job. Good job. Very good. Excellent.
Overruled on cumulative, I will admit. That was 2695.
Yes, Your Honor.
What's next?
I'm not sure we'll play it, but I'd like to have it available anyway. 26903, video of Maya again, same date essentially, 7/28/16. It's her dancing in a wheelchair to a Meghan Trainor song, or big thing, and that ties in to some other testimony about what happened to her with nurses and Meghan Trainor. Children dance a lot differently than they did when I was that age. Like I said, I'm not sure. We're kind of moved to admit.
Cumulative.
I'll allow that one. I will tell you, Mr. Anderson, though, we're getting pretty close to
Yeah.
my limit on the number of these videos.
I think that's about it on that.
And this is under the, I did not admit in the other dancing video.
Yes.
Because you withdrew it, right?
Yes, sir.
Okay.
We only have one dancing video. Okay.
I think it was the same song, though.
Yeah. Well, that's her favorite song. So she plays it over and over. Okay, what's the next?
Considering we're 7 minutes away from 5 o'clock.
Well, let's get a couple of audios in and then we'll be.
Do I ever get to do my motions?
See, Mr. Altenberg, you need to like
It's a potted plant, I'm sorry.
come sit up front or something.
Yeah, they do need a few more lawyers over there. I've noticed that. They're running short of them.
Oh, you should talk.
2580, Your Honor.
Folks, let's try to keep it.
I'm sorry, the number?
I'm sorry. I appreciate the number. 2580.
The date? Is it a video?
It's a photograph of Maya in 2020.
2580.
Oh, and then we have a number of photographs we'd like to move in.
How many are in this series?
Well, this is a singular photograph, 2580. And Your Honor, this depicts her at the time of her relapse in 2020 and hospitalization.
Cumulative.
Are you going to have other photos of relapse, or is this the only one?
This is the only one I'm aware of at the moment. I think we have very limited evidence of photographic evidence of that. So
What does this photo tell us? Other than she's sitting in a hospital bed.
If you notice her hand and her arm, it shows the weight loss. I think
also the hand is starting to, we need, actually, Maya's testimony will be instructive on this because she's going to talk a little bit about how when the CRPS came back, the symptoms that she was having. So,
and I'm also, didn't realize this, there's 4 photographs in here. If we could scroll through them quickly and show the court. This shows the feeding tube that she was, and again, her collarbone, you can see how much weight she lost. Can you go to 3? Another one with the feeding tube, and there you go.
To be very briefly heard on this, Your Honor, the only concern we have, again, the affidavit written by Ms. Kowalski regarding this was that the stress of litigation and specifically depositions was what caused this, the need for the feeding tube, etc. So we're concerned about the prejudice of them making arguments that this was all caused by counsel.
Well, I don't think it's correct that the only stress she had was the litigation. I recall there being issues with school and think there was something else. So, I think we're going to eventually, as soon as Mr. Altenberg can come to the front of the room, we're going to get an instruction about the litigation stress.
Yes, Your Honor. Thank you.
But I think with respect to this one, can I see the series of 4 photos again?
I would suggest one of them, Judge.
I see one.
we'd like to have the first 2. We need to show the collarbone, and it would be good to show her in the wheelchair. Or bed, sorry.
So what's number 3?
Looks like 3 is a close-up of 4.
Okay, I see 1, 2, and then either 3 or 4 as showing different things. So I'll give you 1 and 2, and then I don't care between 3 and 4, but 3 and 4 seem to be the same thing.
We just need those 2.
All right, we'll take
Well, okay, we'll take one more.
we'll take 3.
Okay, so 1, 2, and 3 can come in, but 4, no. Just to make the clerk's job harder.
All right, Your Honor, the last exhibit number, I believe, that we want to discuss is 2571, and it's a series of photographs taken by Jack Kowalski during Maya's admission in the hospital.
When you say a series, I see at least 51.
Yeah, and we're not trying to move 51 in.
So you're only moving or seeking to move in 4, 12, 13, 14, 17, 18, 24, 28, 42, 45, and 51?
Yes, Your
Judge,
Honor.
I would point out that I think 2571-001 is already in.
Yeah,
that one looks familiar.
When I get to my cumulative argument,
Show
I would
4.
point that out.
Okay. The purpose of these photographs, well, the selection of these photographs is based on that they're taken on different dates during her hospitalization, and they show the presence of either dystonia or lesions over the course of her hospitalization at Johns Hopkins Ellen Springs Hospital.
Okay, what's the next one?
So that's 4. 12 is the next,
And what's the next?
and then 13. 14.
Wait a second. Go back to 12, please. Okay. 13. So go to 14, please. $17.
17.
That one.
Isn't that already? I've seen this one before. Is this one already in?
I don't know,
Not
a
by
similar
our-
one
not by
was.
our count.
Don't we have something like this already?
Well,
Different times.
the date's important, Your Honor, to juxtapose against the medical record. So that's why we've chosen these
Okay.
dates.
18, please. 24. $28. Haven't I seen, don't we have photos of, like in the Christmas dress and the head? I think we've already seen several of those.
I think you might be right as far as December, Christmas Eve 2016 is concerned. So we can withdraw on 28. What is that, 28?
Let's go to 42, please.
Now we're on New Year's Eve, or close to.
Shows the progression of the lesions.
45. So essentially, 42 and 45 are the same day and showing the same thing.
One day apart, Your Honor.
Can you go back to the 42?
Your Honor, this date range here is particularly important to us because this is right around the time when the hospital began taking the position that Maya was self-inflicting these wounds. So to show their presence over a period of time and their progression is important.
And 51.
January 5th.
I see that. Defense position.
Cumulative.
Okay, the court is going to find that each of the photos that I'm going to admit show a different, unique condition at a different time. So I'm going to admit in. Wait a second. Did 2, 5, 7, 1, 4, 12, 13, 14, 17, 18, 24, 28 was withdrawn, so that is not being admitted. 42, 45, and 51.
Can I read those back to you, Judge?
Yeah, do you want me to just read them again?
Please.
All in the series of 2, 5, 7, 1, 4, 12, 13, 14, 17, 18, 24, 42, 45, 51. Is that all the exhibits that you're going to deal with today?
We have some limited time on Monday morning to discuss any additional exhibits in this list that we can narrow down further and maybe come back with 5 or 6.
Yeah, we'll try to do it as, we'll tighten it up, Judge. We know what you're
You need to
approving.
really tighten it up.
Yes, sir. We needed a little bit of guidance on what the court wanted, but now we know what to do.
What are you doing as far as witnesses on Monday?
I'm gonna call Jack back, and then I'm just asking him the questions from the rebuttal of Beatty. So he should take, I hope they're not gonna cost long, because there's only a few questions. He should take 45 minutes. Then Maya will be on. And Maya, I think, will take the entire day with Cross. I mean, maybe not, but I expect to have an hour and a half, maybe 2 on direct.
Are you going to do the child victim hearsay statements with Jack Kowalski on Monday?
I'd like to, as a predicate to Maya's testimony.
So Monday is Jack Kowalski followed by Maya Kowalski.
Correct, Your Honor.
Now, Mr. Whitney was talking about timing.
I think you might understand there's up for an hour and a half to 2 hours.
You think I need more?
I really
need more than 2. Mr. Whitney's telling me I might need 3.
Jack took all day.
Yeah.
Judge, here's our issue.
We're doing the best we can to get them on and off. We're cognizant of our time. but I think we need to call Jack. The jury wants to hear from him, and then as to Maya, there's a lot of evidence that goes in through her.
Judge, here's our issue. They've already called Mr. Kowalski once. This will be the second time, and then they're gonna put him on a third time for another issue, and maybe a fourth time for another issue. We believe that they should be calling him just one more time and finish his testimony as opposed to continually putting him in front of the jury.
You know, it's their shot clock, and if they want to keep calling somebody back multiple times, so long as it's not like a doctor that is being inconvenienced or a nurse that's being inconvenienced. If it's a party, it's fine, but the shot clock's going to keep running.
And very briefly, my understanding is you, just for notice to the other side, you plan on calling him for the purposes of talking about the issues that you wanted to, and potentially child victim hearsay? You're not getting into damages, I'm just trying to prepare for the.
No. I hadn't planned to do that. I had planned to call three of them back for a short session on damages before, right before we put on Bifolco or like that,
Okay.
but after Brewer.
Thank you, Mr. Anderson.
Mr. Oldenburg.
I was hoping maybe Monday morning I could get hearings on those two jury instructions.
How much time do you?
I think I can do both of those depending on how they respond in 15 minutes or less. So.
If we start at 8:15, and we're going to start with Mr. Altenburg issues. Okay. And I need y'all to remind me to do that, so I don't just immediately go to exhibits.
Which two instructions are we discussing? So I can relay to Mr. Elliott.
The limiting instruction and then the one that I sent in this morning.
Okay. Wasn't aware of it.
One's the Facebook limiting instruction, and then the one on litigation stress. Is that?
Yes, it's the litigation stress.
Thank you.
And perhaps
I did not file that. I sent a copy to everyone, but I can file it.
And did Mr. Elliott, did he oppose, or have y'all worked on it?
Frankly, I've had very limited contact with him on this week.
So perhaps maybe tomorrow, you and Mr. Elliott could spend
I'll see
a
whether I can
moment
send these to him
visiting.
and see if I can coordinate.
Yes.
And Judge, if we could have the tightened up exhibit list, so we're not spending time looking at things that they're not gonna try to put in.
Can you get them the tightened by, let's see, today's Thursday afternoon, right? So by lunchtime on Saturday? Does that?
That'd be fine, Judge.
We can do that.
So noon Eastern Daylight Time on Saturday, the exhibit list that's tightened.
Understood.
I hate to ask anything else because I really think we need to call it.
Yes.
So I'll see everybody on Monday at 8:15. 8:15.
Thank you.
Thank you, Judge.
Thank you.
Have a good weekend.